One juror. Yeah, we're waiting on one juror. Let me know when you're ready. All right. All right. What is it? You just waiting on it to crank up?
They're huge voice files because
Okay.
they're like hours and hours, so they're not.
Mr. Lamb, I'd like to address some matters if you could step back to the. You can leave that there. I just want to.
Well, I just gonna set it over here so I can use it while you're
Okay.
addressing other matters.
What I plan to do is, because it is morning, and I've gotten the impression from the jurors that they need breaks during the morning. And so, every hour or so during closing, regardless of where we're at, I'm going to take a pause for the jurors' sake. Brandon, at the back, I want to limit the incoming and outgoing traffic during closings. If I look at you and nod my head, I want you to go to the outside and don't let anybody else in except in between the arguments. Okay, hopefully it won't be a problem, but I don't want a lot of distractions going back and forth while the attorneys are giving their summations. The other thing, the closing arguments are the part of the process where the attorneys, try to persuade one way or the other. So they're gonna talk, and they're gonna make argument, and it's gonna offend people that are in here that are interested in the case. I did not tolerate any reaction to those matters. So if that becomes a situation, then we'll stop, and somebody could end up being removed. Brandon, if you tell Deputy what I just said about the disturbances, so or about the coming and going. Sharon, can we check and see what the status is on the jurors? I know they're supposed to stick their head in and tell me. We were waiting on one juror according to the bailiff when I walked in. I also put I think Mallory gave you the verdict form for each of you to use during your closings if you wish to. Otherwise, is everybody ready to proceed?
Yes.
All right. As soon as the jurors are here.
Still waiting on the
Okay. When we have all 12 jurors, I'll come back in and we'll go right into the closing arguments. If anybody needs a break, now would be the time.
Gotta get into it.
Still waiting.
Ma'am?
Judge,
Yeah,
she said we'll be here in 10 minutes.
in 10 minutes. All right, we received a message from the juror that she will be here in 10 minutes. I'm inclined to wait. So we'll be in recess for at least 10 minutes until she gets here. So let's bring the jury in. Good morning. Good morning. Is everybody ready to proceed? Yes. All right. We're about to allow the attorneys to present their closing arguments. The state has the burden of proof in the case. Well, first of all, did everybody have a good evening? Did you all follow my instructions yesterday? Yes. All right, thank you. We're about to proceed with the closing arguments. The state, having the burden of proof, has the right to open and conclude the arguments. During the morning, as these arguments proceed, we'll take breaks, even if we're in the middle of one of the attorney's argument. I don't like to do that, but I will most importantly want you to be comfortable and alert, all right? Mr. Lamb, does the state wish to make an opening argument?
I do, Your Honor.
All right, you may proceed.
Just one moment to move this over. Make it up there yet? Thank you.
Please, everybody, make sure that your phones are off.
Tuesday morning, I stood here and I told you that what this case was about was the short life and the horrible death of one precious little boy. By now, of course, you know who that is. It's J.D. Angeles, born June 25th, 2022. He died January 14th, 2024. The state, of course, has charged TrinityPoague with causing his death. She's charged in an indictment which contends that she committed several violations of the law, several huge crimes, beginning with cruelty to children, aggravated battery. From each of those felonies, there's a charge of felony murder. And then finally, there's a charge of malice murder. And when you get to the point where you're having to move from this, we have this fact, and we have this allegation. How do you get there? And there's really not, I mean, the judge is going to tell you what the law is, okay, but there's not really in the judge's instructions, typically there's not really a roadmap for how you get there. And so what I would suggest to you, ladies and gentlemen, is this. And again, I mean, it is, you are free to decide the case however you choose to decide the case and by whatever process you choose. But I would suggest to you or submit to you that you might consider this process. And that is, you start with the facts that are beyond dispute. The things that you know that are established, where there's just not a realistic argument, where there's not a realistic dispute, where there's no controversy. Start there. And then the reason you start there is this, because you can resolve the disputed issues in the way that is most consistent with the facts that aren't in dispute. Okay, so if you know that, that 2 and 3, that these two things are true, and then you're trying to decide whether this third thing is true or not, you can take that third thing and view it through the lens of what you know, of what you've already established or what you've already decided is an indisputed or undisputed issue. Once you've determined what happened factually, then you can apply the law to the facts. And of course, Judge Sizemore is going to give you a long explanation of what the law is, and he's going to tell you something very much like this. It's something that says to the effect of, you are the judges of the facts and the law, that you determine the facts, and then you apply the law to the facts to determine the outcome of this case. So for this part of my argument, what I want to do is this, ladies and gentlemen, is focus on some facts that are absolutely, at this point, indisputable in this trial. There is an indisputable medical fact in this trial, and that is that the cause of this child's death was massive head trauma. There's no question about, did he die because he had an infection? Did he die because he lost his leg and bled to death? Did he die for any one of these other reasons that might cause someone to pass away? In this case, the unanimous opinion of the medical witnesses that you heard from, the physicians that you heard from. I'm not talking about Dr. Gamble now. I'm talking about the actual doctors, okay, who testified in trial. Okay, Michael Bussman, who's practiced medicine in this town for 30-something years. Jill Olin, who has practiced medicine in this town for 15 or 17 years. Dr. Anthony Clark, who has served as a medical examiner both in Georgia and Florida, for the last 30-something years, who's done 8,100 autopsies, who's testified in court as an expert witness hundreds of times as to the cause and manner of death. They all agree this child died from this wound. Now, there are other injuries, and we're going to talk about those later in my argument, okay? But for right now, I want you to focus on this one, and that is that it is an undisputed fact that this child died from head trauma. It's also undisputed that the trauma, or the cause of the trauma, is also undisputed. Dr. Clark says it was a tremendous impact to the back of the head. These are quotes I wrote down while I was listening to the testimony. He says it was a tremendous impact to the back of the head. Dr. Bussman says it was a direct, high-impact blow. There's not a question as to whether or not or how you get this kind of head trauma. In other words, it's beyond controversy. You can't get this kind of head trauma from bumping your head on the door back here, or you can't get this kind of head trauma because you have weak bones. You can't get this kind of head trauma because you have some rare childhood disorder like Paget's disease or Alagille disease or whatever it was that was brought up. Okay, rare childhood disorders, bone diseases, all these other things. None of those things will cause the trauma that this child suffered. To get this kind of trauma, it is an undisputed fact that it must be a direct, high-impact blow. The time frame between the trauma and this child's death this child's appearance at the emergency room and subsequent death is also not reasonably in dispute in this case. Okay. None of these doctors who testified even allow for the possibility that this child's injuries were suffered the day before or the night before or even 3 or 4 or 5 hours before. They certainly weren't built up over time. It wasn't that he had a partial occipital and parietal skull fracture, with a massive hematoma at the back of his head and 3 or 4 other brain bleeds across his head, and that they just built up over some period of weeks. That's not what happened. The high impact trauma that this child suffered would immediately, according to Dr. Bussman, very quickly, 30 to 60 minutes at the most, result in essentially a full onset of symptoms. Dr. Olick said there is 0% chance of normal behavior from the time of impact forward. So what are the chances? I ask, what are the chances? What are the chances that this child could have sustained this blow and behaved normally for any period of time? And the answer was, there is a 0% chance of that. Dr. Clark makes it 3 for 3. The time frame that Dr. Clark establishes is this. He says that at a minimum, initial symptoms like drooling, staggering, vomiting would have appeared very quickly, within seconds to minutes after the impact. He said, in his mind, you probably would be in terms of the initial onset of symptoms. In his mind, it's probably more like seconds than minutes before the symptoms begin. Those facts have been established, ladies and gentlemen, by the evidence that you heard in this courtroom. Okay, you don't have to Google it. Okay, you don't have to have a discussion about what happened, when you were a child or when somebody else was a child or those kinds of things. You don't have to talk about, what what do people in the medical community really think. Okay, we're not talking about vaccines or something where some people say, it's this, you should take them, and some people say you shouldn't and all that. We are talking about medical facts as to which there is no disagreement. That brings you to this point. The question for you to answer as a jury is this: who could have caused the trauma that killed this baby within the time frame that it had to have occurred? Okay? No telling. In any number of things, any number of people, any number of circumstances could certainly have caused severe trauma to this child at some point in time. But that's not really the question. The question is, who could have caused this trauma within the time frame that you have available? There's an answer to that question. From 8:00 p.m. Saturday night, when they were in Albany, Georgia, on January 13th, 2024, until about 12:30 Sunday afternoon, January 14th, okay, for that whole time period, there was only one person who was ever alone with this child. One. There was one person who was ever alone with him for any period of time during that 16 and a half hours. You know who that was? That person was TrinityPoague. Not only that, ladies and gentlemen, when you focus on this time period and you reduce it down to the time during the time frame that the doctors talked about, the time immediately prior to the onset of the symptoms, the answer becomes clearer. One person was alone with JD during the time immediately before his symptoms appeared. That one person was TrinityPoague. At 11:55 a.m. on Sunday, J.D. Angelus was a healthy little boy. By 12:30 p.m., he was in a literal death countdown. It wasn't a question anymore as to whether or not he might live. It wasn't a question anymore as to whether he could be saved. It wasn't a question anymore as to whether he would ever be able to grow up. By 12:30 p.m., at 12:30 p.m., he was dying. There were symptoms that appeared during this time frame that appeared when Julian Williams, Jay Williams, when he pulled up to the dorm and he got out of his car and he went inside to pick up that child. Actually went inside to put down the pizza and the drinks because he thought they were going to have lunch. But when he went in and he picked up that child, there were immediate symptoms that the child was suffering right then. The child was essentially unconscious. Okay? The testimony is that his head was limp, that he couldn't hold his head up, that his body was limp, that his head was bobbling around. He was nauseated. Before he got to the car, or as he was getting into the car, the child threw up all over his daddy. He was draining CSF, cerebral spinal fluid. Okay, the fluid that circles your brain, that encircles your brain, that helps protect you from impacts, that helps protect your brain from shock, from harm. Okay, that fluid, by the time he got to the hospital, was literally coming out of his nose and his mouth. It was no longer contained here where it's supposed to be. It was here because of the head injury he had suffered. He was in cardiac or respiratory, cardiac and respiratory arrest at that time. When he got to the hospital, he wasn't breathing and he didn't have a pulse. Those symptoms, when you go back to the time frame that the doctors established, those symptoms would have had the impact that caused them, the impact that caused those symptoms would have had to have occurred within minutes before the child presented at the hospital. During those 35 minutes that we're talking about, okay, these 35 minutes right here, 11:55 to 12:30, during those 35 minutes, one person and only one person was alone with that child. TrinityPoague. I want you to think about some of this, ladies and gentlemen. You have a circumstance where you have two people in a room. We see this in cases that get presented. I mean, I guess prosecutors everywhere see it at some point or another. You have two people in a room. One of them ends up dead. There's a fight. One of them ends up dead. Okay? You would think that's an easy case, right? Like, you have two people, one's dead, now we know who did it. Okay? But those aren't typically easy cases. And the reason they're not easy cases is because the person who is alive says, it wasn't my fault. It wasn't my fault. He attacked me. He threatened me. He did this, he did that. I was fighting for my life. Or he angered me so badly that I didn't really have a choice. I was overcome by the emotion of the moment, so it should be voluntary manslaughter or something like that. Okay? So there's a myriad of issues that sort of layer on top of each other when you have two people in a room. Except in this circumstance, okay? Because the two people in the room during those 35 minutes were J.D. Angelus and the defendant. Those are the two people who were in there. There's not an argument that can potentially, possibly, in this universe or beyond, there's no argument that can be made that It was that it was caused by the child, that the child, was aggressive, that the child was the initial aggressor, that the child, attacked her and she had to defend herself. Okay? So it makes the two people in a room situation, instead of it being a hard case anymore, it becomes an easy one. I'm about to wrap up here in just a moment. Sit down and turn over the podium to Mr. Gamble. But I want you to think about something, okay? As you listen to him nitpick the evidence, and you heard the examination, you heard opening statements, you heard the examination of various witnesses, and so you already know it's coming. But as you hear him nitpick the evidence, I want you to keep this question in the back of your mind. What do any of these things really have to do with the death of J.D. Angeles? Did poor parenting, missing well baby doctor appointments, misusing a car seat, did those things kill this child? No. Those things didn't kill this child. Would testing some dirty diaper that came out of the dumpster or testing the vomit that was on Jay Williams' shirt and jacket, would testing those things, would interviewing some people in Colquitt 50 miles or 75 miles away from, no, it's more than 50, right? They're like 75, 80 miles away from where this happened. We're going down to Colquitt and interviewing some people. Would that put somebody else in the room with Trinity Poague and the baby? Would that have put somebody else in a position to inflict this trauma? No. Those tests, those things, you're not going to get that. Did a bottle of rum or a dispute or a fight over social media passwords kill that child? No. What killed that child was, with beyond dispute, it was a massive, tremendous blow to the back of his head that cracked his skull from here to here. So, there's a smoke and mirror show coming, though. I promise you. There's a smoke and mirror show coming. And I was thinking about this in terms of how do you see through smoke? Okay, how do you clear the smoke? Right? Firemen, okay? There's a house on fire. Firemen go in and there's smoke everywhere. They have to get through. They have to navigate through. The smoke will kill them. I mean, if you just breathe it in, it'll kill you. If you just accept it, if you just let it be there, if you don't fight against the smoke, it'll kill you. So what they do is they put on goggles, and a face mask, with a breathing apparatus and a breathing tank so they can navigate their way through the smoke until it clears and they can get to whatever it is they're trying to accomplish. That question, ladies and gentlemen, that question is, that provides your goggles, okay? That provides your breathing apparatus for getting through and seeing through the smoke that's coming. That girl killed that little boy. She killed that little boy. She cracked his skull out of anger, out of malice. We'll talk about all that later. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred. Don't let these other things that don't have anything to do with the answer to that question, who killed J.D. Angeles? Don't let these other things cloud your vision and fog your mind. Thank you.
Thank you, Mr. Lamb. I'm going to let the jury step back in the jury room while the attorneys switch over their computers and such, and go ahead and take yourself a respiration. We'll be back in 10 minutes. Yes. Ma'am? Oh, Lori's not back yet. You good? All right, let's bring the jury back in. All right, Mr. Gamble.
Good morning, ladies and gentlemen. This will be the last time that I have an opportunity to speak with you. I have as many as 2 hours to speak, and I can assure you it won't be that long, and I'm sure you'll be glad that it will not be. But what I have to say is important, because some of the things that the district attorney said just a moment ago, I'm not going to try to address that particularly, except one thing he said was that this is an easy case. And when I first came before you, I told you this was a case in which the state had a case that was filled with suspicion, but empty on evidence. And then this is exactly what I mean. Would the state consider this an easy case that did not require any investigation, did not require much to be done because they were so sure of who they thought it was that was responsible, they failed miserably in every phase of the investigation otherwise? And if you look at the evidence, the question that was put on the screen about whether or not any of this has to do with the death of the child, this is not a case about whether or not the child died. We all know that. If that is what the state needs to prove, they have done that. And we concede that. That is not what this case is about. This case is about the state of Georgia accusing this young lady of a very serious crime of murder. And when the state makes a claim like that against someone, it is their sworn duty to prove it. And not just a little bit, but prove it beyond a reasonable doubt. That meaning that if there is any other reasonable explanation for what could have happened, any at all in your mind, you cannot come back with a guilty verdict. Now let's look at what we have in this case. And I'm going to go through several things. You got to imagine I'm having to unwind quite a bit of evidence that's come through these last 4 or 5 days. But I'm going to try to take you through, not piece by piece who testified, but about certain things that matter. And the first one is, and a very important one is, that Agent Gibson came and testified. You remember, he is the person who said he is a crime scene specialist. He also has special training in crime scene preservation. He said he was told to go to a particular location where they believed the crime scene occurred. That would be the dorm room at the Oaks of TrinityPoague, where also Mr. Williams had been staying and the child. Now we know when he went there that really quickly after arrival at the hospital, an officer was posted at the door and it was taped off and someone stayed there, and so no one came back to that room after Mr. Williams and Ms. Poague left that room. We know it, one, because it was roped off and had an officer there, but also they've got video. So we know if someone had come through in that dorm and tried to mess with anything from the time they left until the investigator got there, that's not possible. Investigator says that's right. So we don't have a question about, has there been a cleanup in this room? Has there been some tampering in this room? Nothing has happened in this room except the people left, and they left it in whatever condition it was in at the time they left in a hurry to go to the hospital. And what did he tell you about his investigation? He said he took photographs of everything that he saw in each room because they like to show the setup of each room to begin with and let you know everything that's there. And then his secondary purpose and most important purpose was to gather any evidence that he felt was important to the case that could be used in this case to prosecute the case, whether it be against Ms. Poague, whether it be against Mr. Williams, whether it be against some third party, who knows, but to gather that evidence. And I asked him, at the conclusion of questioning him, isn't it true that you did not obtain a single piece of evidence that was any use to you in this case? And he said, yes, that is true. Not one thing. I asked him, did you find any blood in that dorm room anywhere in that location, in that vicinity? His answer was no. Did you collect any type of human fluid that you thought would have been beneficial to tell you something? He said, no. I said, did you find any type of weapon in that room that might have been used, any kind of instrument that could have been used to cause blunt force trauma? Did you find a bat? Did you find a paddle? Did you find a statue that's sitting in the room that might be used? And his answer was, no. I found nothing that I think could be used as a weapon. I asked him, did you find any place in that room or those couple of rooms where it looked like someone could have hit, an arm of a chair sitting out or a high countertop that might have a sharp edge, anything that looked like it could have been a child pounded into? Did you find anything that would have drawn your attention where you got evidence? He said, no. So what about the walls? Did you look at the walls to see? You would look at that. Yes, I would. Did you see anything? His answer is no. So we know that the state claims they have a crime scene, but a crime scene in which they have obtained zero evidence from. I'm not talking about a little evidence, zero, unless you believe Agent Ford, I think, said they did get a receipt from Walmart that proved they went to Walmart to buy the drinks. I'll give them that. That's it. Nothing of evidentiary value from a supposed crime scene. Now remember, they said this is a violent, massive force injury. Yet there's no evidence within that room of anything that occurred like that. And I remember I asked the agent, I said, well, have you ever heard of luminol? A lot of people I know have heard of luminol. Luminol is used to spray it across a room in case you don't see blood evidence. But just because you don't see it doesn't mean it's been cleaned up or it's only a small spot and you can't see it with the naked eye. Spray it with luminol, turn the lights down, turn on a certain light, and if there's any particular speck of blood, it'll light up. And I asked, did he do that? And he said, no, he didn't do that. He didn't offer an explanation why. He just didn't do that. It is inconceivable that someone individually, intentionally, did the harm to this child in that way, and it didn't leave some type of forensic evidence in that room. And remember, you also told the child supposedly was throwing up on the way out of the room, and there was no throw up coming out of the room into the hallway. No evidence. The state is required to provide evidence. A defendant comes into a courtroom under the law cloaked in innocence, and it does not be removed from the defendant from the time they enter until they leave, unless some actual evidence comes in that can disprove that innocence beyond a reasonable doubt. But their crime technician, the one that's charged with collecting evidence, has collected nothing. So we don't know if that's the crime scene or not. We didn't get any evidence from it if it is. And we also know when I interviewed and questioned most of the arresting officers and GDI agents, anyone that was involved in this case, the autopsy people, all of them, we do know that the child suffered from blunt force trauma. We know that. But not a single person that I asked, number one, I asked each one, can you say, based upon what you saw, who did that? And the response for each of those persons is, no, I can't. I can't tell you from what I'm looking at, from what I observed and what evidence I had in front of me. I could not tell you. I could not say, yeah, I can tell you so-and-so did it. I can't tell you that I took ballistics from a gun and I can show it matches John Brown's gun. No. I can't tell you I found a weapon that was owned by somebody and now it's been used. And more importantly, I can't look at the body and tell you of a single mark that shows there's anything been done to it other than it has blunt force trauma but not in a sense of you can see a paddle mark or a baseball mark or something that says someone did this to this child individually. They have none of that. So they don't know who, but they also don't know how. I asked the autopsy people, I asked Agent Ford, I asked every one of them, do you know how? What happened? Well, they've got some theories. Maybe this, maybe that. I don't know. We just know the child had significant injury. So now we don't know where the crime scene is. We don't know necessarily who did it. And we don't know how they did it. We don't have any type of weapon. We don't have any type of instrument that supposedly caused it. And you're left with some speculation of, well, could it have been just the hands of someone, just the person themselves? Could they have done that themselves? And somehow grabbing, somehow punching. TrinityPoague have done that. She have grabbed a child and done that with her hands. Well, you would think if that's a possibility that the GBI would have looked at her hands, photographed her hands, would have looked to see if there was any signs that she used her hands. Because remember again, this is a violent force, blunt force trauma. She used her hands because of that, and you talk to her within a few hours of it, and you look at those hands, it's going to show. Whether they're going to show redness from blows, whether they're going to show scratching, whatever it may be. And it took quite a bit of pressure, of course, according to Dr. Clark and some of the others that testified. And we also know Mr. Williams was around the child. Who's more able to use great force to cause injury? Who knows who caused injury? But if there is injury, we do know from Mr. Williams, nobody looked at his hands either. They didn't do anything to check that. And they didn't do that because they weren't going to check on Mr. Williams anyway. Because they were already down the rabbit trail they went down to begin with. That TrinityPoague is guilty and we don't need to look at any other evidence. Now you know that because I talked to Agent Ford, and I asked her about what their investigation do. We know that she talked to everybody that she knew in that dorm or had agents with her do so, interview them all. Try to find out what they know. She got a phone. She got a phone of Mr. Williams. She did a few other things. She talked to different people. Well, then when I asked her about what efforts she made to try to find out anything about Mr. Williams or his sister, Ashante Burr, what did they tell me? And the reason I asked that before I go any further, remember I asked that agent, I said, when you have child abuse cases, isn't it true that sometimes or often you find that a child has had injuries before the situation that leads to their death? They kind of show there'd been abuse in the past, but now it's occurred. And she said, well, not all the time. And I said, but sometime, right? And she said, yes. And I said, isn't it important to then look, to try to see, to try to find out if that's the case? Now, she discounted and said no. Why did she say no? Because we already had a dead child here. I know it was in that dorm room. I don't need to look anywhere else. That's what she told me. I don't need to look anywhere else because I know where it happened. That's it. I don't need to look. I said, did you go to the house where the child lived and at least look at the house? No. I said, you wouldn't even know how to get there. Right now, if I wanted you to take me to where the child lived, and the answer is no, she wouldn't. Not even looking to see what type of condition was she living in. I don't know. No one knows. They didn't investigate it. Did they talk to any neighbors to see anything about the relationships going on? No. Did they talk to anybody that he worked with? No. Did they go to his workplace? No. Did they make any effort to find out? No. Because they'd already gone down that trail. And they decided at that point that this is the story we'll tell, and you'll see, and I'm going to talk about this in a little bit, about the testimony being shaped to make sure it fits over here, and struggle and fight no matter what to keep it there. Because that's what they decided early on, and they don't want to break away from that. But now you have a case, you got no evidence. None whatsoever about how the blunt trauma was occurring. You don't know for sure where it occurred. You don't know who did it, but they say it's an easy case. They say now we just got to look at it and we should be fine. But you know, maybe the most important witness that came in this courtroom was the one that's not tied up and connected with everyone else, and that's Dr. Busman. You know, the rest of these folks, they got some allegiance one way or another. GBI can say what they want to. Dr. Clark been working for the GBI forever, and yeah, he's going to testify for the GBI, and you can bet your bottom dollar he's going to support whatever side he came in the court to testify about. He's not going to break off of that. And you got these law enforcement agents, they've already gone down the rabbit trail, they've decided what they know, they're not going to break off. But Dr. Busman didn't ask to be in this case, didn't want to be in the case. He had one duty and one thing he had to do. And that was he was an ER doctor, and he had to try to give some type of treatment for this child and see if he could save it. That was it. And then he got called to come testify. And he had to do that. I'm sure he didn't want to. As you could probably see at least somewhat, he wasn't that comfortable in testifying, but he testified. So you can bet he was trying to be truthful about what happened. He told you some things that were extremely important. And one of the things that, as important as anything, I believe it's exhibit number, let me make sure I got the right exhibit here. Exhibit 26 is the medical record from the treatment that he gave the child when he came to the emergency room and all that happened. And that record's already been introduced. It's an authentic record. You're going to get it back with you. You can look at all of it. And it's got some pretty important stuff that's contained in it. The most important stuff it's got that's contained in it, if you look at that document, and I'm going to ask you that you do when you get the chance at the end of this trial, you're going to see that there are numbered pages. There's two sections of numbered pages. You first look in, and there's just a bunch of preliminary stuff with no numbers on it, maybe 20 pages worth, 15 or 20. Then you'll come up with pages 1 through 39. Well, in that section of 1 through 29 on page 23, you'll need to look at. And then you'll see a second section of 1 through 28, and on that section you need to look at page 20 and 21 of those. Now, why do you need to look at those? Because those medical records on 3 separate occasions say within the record that the father presents bedside and states the child fell around 5 minutes prior to arrival. Why is that important? First of all, we know from Dr. Busman that the only person bedside was the father. The girlfriend, TrinityPoague, was not there yet. So the only person, it's not a mix-up that they said he told. We know that because it's in this record. Now, what was interesting about that, did you see how the state struggled so hard when they got back up to pull that out of the record? To say, well, didn't that get entered a few hours later? I mean, that didn't happen right away. Trying to insinuate that maybe some mistake was made. Maybe that's not really what got said. On, and Busman, you know, you can see he was almost confused. Why is that happening? But I'll tell you why that's happening. Because they didn't like what Busman had to say, and they didn't like what he had to say because it's a lot more than just the father coming in with a story that we know is not true. We know that the child didn't fall 5 minutes prior, or don't think he did. Or if he did, maybe the father knew it and we didn't know it. But they try to then claim that maybe Ms. Poague had told him that, and that's why he told the doctor that. Remember when I got Agent Ford up and started asking her about the interview she did with Mr. Williams? But before I put her up, I asked Mr. Williams, did you tell the agent when she first interviewed you what you believe happened to cause the injury? He said, first interview, yes, I did. Second interview, I said, did you tell her? Yes, I did. And I put the agent up and asked her, can you tell me, here's your summary. If you look at it, do you have it from the first interview that first occurred when you got there with Mr. Williams? Yes, I do have it. It's 10 or 12 pages long. Okay. Can you turn to a certain page there and tell me, if you're looking at that, tell me anywhere do you see where Mr. Williams says what he thinks caused this injury? She said it's not there. In fact, what she read from that report was him saying that he came back to the room and asked Ms. Poague what happened, and she said, I do not know. And then it said that nothing else in the report. Now first, you know, the agent wants to avoid that too. She doesn't like that. She's protecting her story now, trying to make sure that we got the blame for Trinity. That doesn't fit the pattern. So she said, well, you know, it may be in the report somewhere else. And what I told her, we got time. Read your report. Go through it. When you get through, let me know if you find it. Well, they sat here a few minutes, 5 or 10, but guess what? She finally said, I've looked. And I said, you find it? She said, no. Well, then here came the real squirm. Let's say maybe I just didn't put it in the report. He may have told me I just didn't put it in the report. That's interesting. You've got a trained GBI agent that is taught that anything of importance will be put in a summary report to make certain that you're preserving that. We know that. We've heard testimony about that to some degree, but yet someone tells them because they believe of what could have led to the injuries to the child, and they don't put it in the report. But maybe they got told and forgot it. And she says that on the first one. Well, the second report, I asked her the same litany of questions, said, what did he tell you there? And he said in that report, absolutely, he did not know what happened. He didn't say, but my girlfriend told me something. He didn't say that I know something. He just said it didn't happen. So we know when he went to that hospital, no one had told him anything about a fall. That came from his idea. That came from his mouth. Now, if he got interviewed by the GBI and he knew it, you can bet your bottom dollar in that only an hour or two after all this occurred, he would have said, yeah, the girlfriend said this. So we know that came from him. But we also know he didn't just tell the hospital that. Lieutenant Allen told us. He came up when it was going on, remember? He saw him come into the emergency room. He saw him standing in the doorway watching while they were doing the workup. He pulled him back and talked to him and asked him what happened. And guess what he said he told him? That my son just fell face down a few minutes ago. Again, twice he's told that version. Twice he's told a different version to the GBI. And you know, if you really get down to it, looking at some of the questions for Mr. Williams, let's talk a little further. Remember when he got on the stand, he told those two things that it seems pretty apparent that maybe they weren't exactly on the up and up, what he was saying. Well, let's get to the third one. I asked him about being interviewed the third time. And the third time was important to me, maybe more than some other people, but I wanted to know, at the time that he was interviewed, did the GBI agent allow his sister to come in and be interviewed with him in concert? And he said, well, yes, she came in, but when she came in, I left. I said, so you're saying if they asked her any questions, you left. And he first said he wasn't really asking questions, just looked at cell phone stuff. But then he said, no, if she asked anything, I left the room. That's what he said. That's what he told us, right down that witness stand. What he said happened. Now, it's important because, remember, I was asking the agent earlier. I asked her when we were talking about Mr. Williams and TrinityPoague, I said, when they were at the hospital, did you just interview them together? I mean, they were already there together. She said, no. And I said, why not? She said, of course not. I wouldn't do that. Why? She said, well, you know, it wouldn't make any sense. You would divide them up. And I said, that's because it's protocol from the GBI. And she said, well, I wouldn't say it was necessarily protocol. And I said, well, you think it's from training? And she said, well, I think training might tell you to do that, but it's common sense that you would never put two people in together to interview them. I said, you wouldn't do that. She said, no, I wouldn't do that. Well, now Mr. Williams talks about that. And I brought the agent up on the witness stand. And I asked her about it. And she got amnesia. She said at one point, it's been 2 years, I'm not sure. Is that the standard we're using here for this case today? That it's been 2 years, so I'm not sure. So everyone that's come in from the police department, well, it's been 2 years. I mean, I'm not sure we can depend on anything if that's the case. It's been 2 years. I'm not sure. Are we to believe that agent hadn't reviewed her case file before she got here today? Or yesterday when she testified, or starting on Monday? She just came in after 2 years and just winged it? You can bet your bottom dollar she'd already looked at everything. She didn't want to talk about that interview. And then, when we refreshed her memory, what did the interview show? Almost 20 minutes, interview by themselves, 40 minutes with him and his sister together. Now, why would it matter him and his sister? Well, it matters because him and his sister are who is keeping the child. We know from the evidence that the sister actually did more caretaking from the child than he did. She fought me about that some too. Well, I couldn't say that. You know, he might have been some. Well, first of all, she can't say because he didn't do any investigation to determine. But we do know a few things. We know that he came to the college at least twice a week, every week, and he came every weekend. And most of the time without his child. 4 days out of 7, he is not at home. He does not have his child. He has left the child with his sister. She is the caregiver of this child. Now, she is a caregiver of the child, and there is some suspicion of any alleged abuse. It would make a lot of sense to try to separate people and talk about that some, not put them together so they can be interviewed and get their stories together. But that is a sign of what was going on here. Now, we're not worried about them as being any suspect. We've already decided this case. We decided this case, when January the 14th came, by 5 o'clock in the afternoon, it was over. It may have been a couple more days before the arrest occurred, but the investigation had shut down, and nothing else was going to happen. You were just going to have to live with it, and too bad. Why? Because we got suspicion. We have suspicion. Well, it's a scary world out there if your government can all of a sudden just decide I'm a little suspicious and I can arrest you. It's a scary world. But you have that going on, but think about that sloppy investigation a little bit more. It's not just that problem. Remember when I asked the crime scene specialist about the dirty diaper? Now, he already knew that was coming up because we had filed a motion to ask to test the dirty diaper. We wanted to see if it had blood in it. And I've already asked Dr. Busman about it, and he said normally he wasn't sure that you'd have blood in your system from abuse, but I got to ask him, but you could have some trauma at times that causes you to have blood in your bowel system. Can you not? And he said, yeah, you could. I don't think the injury that's caused this death would have caused that, but it could be from trauma. It doesn't take a genius to figure if somebody punches you hard right in this area, that you might end up bleeding from that area through your system. It doesn't take a genius to figure when you hear about boxers when they've been finished a hard 12-round fight that sometimes they bleed out the rear end from it for days on end. It doesn't take a genius to know that you got trauma in here, that you will have blood coming through, and it takes time. I asked Dr. Busman, how long? And he said, well, you know, you can't really say because obviously people's systems work different. Few hours to maybe a day or more. What does that mean? Well, it means there was blood in that diaper. We know a few things. It did not come off of that child on the day the child was taken to the hospital. The child had on a diaper different that they took off of that child at the hospital. There's pictures of that. So it was previous to the child going into the particular situation that led to the hospital. And probably many hours passed or even a day passed back. If it's many hours back, whatever had happened to cause that cannot have happened at the hands of TrinityPoague. Because we have a very short window of time you can claim TrinityPoague did anything, which would be from 10 o'clock or 10:15 on Saturday night until 12 o'clock on Sunday, about 14 hours. That's the only time period she was around the child in that within a week or so. Well, why is that important? I mean, you say, well, that's still not what caused the blunt force trauma. No, it's not. But if you find that to be some abuse that caused that, it certainly would make you start looking a little further as to who might have done it. But if you choose not to investigate it, and worse than that, throw it away. So that this girl right here has no chance to defend it because the test that could have been run cannot be run because they threw it away when they knew it was a test they could run, and he got on the stand and tried to make like he didn't know that. I don't know anything about a fecal test. I've never heard of being able to test it to get for blood. I asked if you ever heard of the test, and he says, oh, no, I've never heard of it. And then he starts realizing, well, boy, that's going to be trouble, so what does he say? Well, I do keep a test for myself that I can test for blood, and if I'd have seen blood, I'd have tested it. He hadn't said anything about that the whole time I've been asking. All of a sudden he pops that one up, but said I didn't see blood in that diaper. Now here's where Dr. Busman really comes in. It's really important. Why he's one of the most important witnesses. Dr. Busman had no idea about the diaper. You could tell that when I asked him. I told him before I asked, you're going to find these questions a little bit weird or something to that effect. You know, y'all finna go on a path that you may not understand. And I asked him about those diapers. And I asked him if he had experience with blood and fecal matter. And he said, yeah. Oh, yeah. I said, oh, you probably tested it, hadn't you? Yes. Is there a test? Oh, yes. A hemocult test. Easy. You know, easy. It's done. I said, is it done quite frequently? He said, well, I don't know about frequently. I said, but yeah, you've done it more than a few times. And he said, yes. I said, if you see what you believe may be blood or suspect it, do you run them? Yeah. He said, there's two ways I do it. Sometimes you can just see blood and you know it's blood. Other times you look and you say, well, maybe I better test it. And I said, so you can observe it? Yes. And then, if you will, put up that diaper number 2. I showed him this photograph right here that you're going to be able to take back with you to the jury room. I showed him this photograph that I'm talking about, that he had never seen, had no idea about it. And my first question was, Dr. Busman, looking at that photograph, does there appear to be blood in that diaper? And he said, yes. I'd say probably so. Now, yes, that sent the state back scrambling again, where they tried to rehabilitate that answer and say, but yeah, it could have been something else. And he finally said, well, yeah, maybe like if there was dye in some food, it might have caused the discoloration. But in his opinion, just eyeballing it, yes, that diaper seems to indicate, you see right there on that screen, blood within it. He said, your crime scene technician didn't think that. Now, you decide which one you want to believe. That's your job. The credibility issue of which one should be believed. Dr. Busman, who's done tests many, many times to test for blood, or this agent that decided to tell you all of a sudden that that wasn't worthwhile. And it's interesting to note that diaper was not unfolded when he got it out of the trash. It was in a ball. That was the first exhibit 1. You'll see those diapers together. He took a picture of that, and then he unfolded them to take pictures. So you know that he knew that that might be evidence. There's no reason to open them up and take a picture. And yet, after he got them, and once he saw what it looked like, he just chunked it back in the trash and left us with no way to test it. He left us with no way to test it because he doesn't care about what TrinityPoague has to say. He doesn't care about that at all because that doesn't fit his case. That wouldn't help him prove his case. That would hurt his case. So he chunked it away. Chunked it away. It's inconceivable that that was done. The crime technician tried to make like 1 he doesn't believe. You can take it down now. He does not believe that it is blood in that diaper, or number 2, that it should be tested. Because if it was tested, it would show, obviously, there was some issue going on with the child. Now, the other things could be going on. The child could have colon cancer, which would be almost unheard of for a 1.5-year-old child. Could have some type of ulcer, again, be extremely unusual for a child that age. If that child that age is bleeding, other than right around the very bottom of the bottom where it might have had some kind of irritation, it came from trauma. If it came from trauma, and we came in the courtroom and show you that, well, then you really got to wonder, why are we not looking? Why are we not looking a little bit further? Now let's talk back a little bit about the statements that there's no one that's been alone with the child but TrinityPoague. No, there's 2 people who've been alone beyond TrinityPoague with the child. Mr. Williams was alone with the child for a period of time. I'll talk about that in a second. And more importantly, the child itself was alone for a long period of time as well. Now, you may remember the testimony of Mr. Williams when I had him on the stand on the day of, the morning when this all erupted. I was going through a litany to try to determine what was he doing and what happened. He said they got up in the morning. He didn't know the exact time. Nobody really gave me a time, but we do know he laid on the bed, and he said he put the child on his chest, and he also said at that time he had ordered the pizza that you know that he went to get. We've got proof of that. Well, you can assume then from that, we don't have concrete evidence of what it is, that he must have ordered the food at some time getting toward the time you would normally eat. In other words, it's unlikely it was 8 o'clock in the morning he ordered the pizza. But regardless, he orders the pizza, and once he orders the pizza, they did not eat the pizza right now, go get the pizza right away. He told us that he got up after being there with the child for a little bit, after having already ordered the pizza, and I'm assuming he's giving enough time for the pizza to be made, so he didn't want to just leave right away. He and TrinityPoague got up, took a shower together. And that's important in itself, together, because we know from the text messages you're going to see that are going to be introduced into evidence. One stream was to Miss Poague's roommate, where she's talking about, in one sense, on the Saturday night, that she had told Mr. Williams, I'm through. He wanted him to go home that night, but he wouldn't, and she said, but I'm going to go ahead and let him spend the night with J.D., but she wants him to leave. it's over. I'll be the first to tell you, we've already heard a bunch of evidence that it was a on again, off again, I'm breaking up, I'm getting back together thing. And so I don't put a lot of stock to I'm broken up and necessarily saying that it was over. But it could have been what was going on. I do know that Mr. Williams had been drinking the night before. He says only a glass or two after he got there with the child. Questionable whether that's true. We know that we have a bottle of liquor that only has about that much in it that he left in the dorm room, and we know TrinityPoague didn't drink it because he admitted she doesn't drink rum and wouldn't have, and it was his rum. But he tried to say that that got drunk at some other time. We don't know how much he did have to drink, but that night we know he went to sleep before everybody else. Saturday night, young man in bed by 10 o'clock already, and sound enough out that when the crying of a child that woke people up in the dorm at 1 o'clock or thereabout, he didn't wake up either time. So it's reasonable to believe he woke up hungover, not happy because his girlfriend is wanting to break up, and he might not have been in the best mood. Or it's also reasonable to assume that maybe the romantic breakup is being a makeup now because they're going to the shower. And if they go to the shower together, and they're young people, and they're making up, the chances are of them being in the shower for only 5 or 10 minutes is pretty slim. I mean, when you go in the shower with your mate, it tends to make the shower a little longer for young folks, sometimes even for old folks like me. But I can tell you, when they go in that shower, they didn't stay in there just 5 minutes or 10 minutes. They are showering together and most likely doing other things. I'm not judging that. It matters to me. But what does matter about that is a 1.5-year-old child is sitting in that little pink chair that y'all saw a picture of earlier and will get a chance to see when you go back to the jury room. And that little chair that sits there, it's not a danger to the child as far as I can tell of something happening in the chair. 1.5-year-old that by testimony by Miss Permott back in October, she was watching the child learning how to walk. He's a toddler, so now he's got a few more months under his belt of walking. I don't know what in the world that child may have done while they're in the shower. I do know this. They were probably in the shower for more than 5 or 10 minutes, maybe 20 or 30 minutes, a pretty long time in the shower. They're in there. The child, I've got children, you've got kids, my kids when they were growing up, my 1.5-year-old boy, if you left him for a minute by himself without looking, he might be on top of a chandelier somewhere. He would climb and go and do all kinds of things. And who knows? Who knows what that child was doing right now? Who knows whether that child himself on that morning climbed up on something and fell back off of it? Who knows? But what we do know is that when the shower ended, Mr. Williams was the first one out of the shower. He testified to that right here and said he got out of the shower first and TrinityPoague got out next. Now, you can say, now, well, so what? He got out and immediately she got out. But he said something else. He said, I went and I was staying there with JD and I was waiting on her to get out of the shower before I left. Well, that tells you two things. Waiting is a term you would use if she's taking a little time. Not I'm waiting as she's following me out of the shower. But secondly, he told us as soon as she got out of the shower, he waved to the child and immediately left, so we know he was fully dressed. So he got out of the shower and got fully dressed before she came out of the shower. So there is a time period where he was the only one around this child. And there is a time period when the child was alone and no one was there. Now, I can't tell you that something happened when that child was by itself. I can't tell you there was something happened when Mr. Williams was there with the child. But I tell you one thing else. I can't tell you something didn't happen either. Because all we know is that was the situation. And so to say that there was no other opportunity for anyone, and the evidence they brought into court was if something had happened, it would take anywhere from seconds to a few minutes for it to show signs. TrinityPoague gets out of the shower, the child is in the chair, he scoots out, she's getting dressed, She's cleaning up around the house, doing the things you do. It might take a few minutes. You can see over in the chair a little ways, but not think a whole lot about it. Finally, if you go over there in 10 minutes or 15 and go, uh-oh, what's going on here? It's something that happened to the child, whether accidental or maybe worse. But you can't discount that. You can't say that's not a reasonable proposition of what could have happened, because it could have happened that way. And we don't know for sure. And we don't know because there's not been an investigation. There's not been anybody that's tried to push on those issues. They just said, we're just going to accept it for what it is. We see you got a child that's not alive, and we're going to blame it on TrinityPoague. That's what we're going to do. That's what they did. And you'll see that Trinity, and I'll talk about this a little bit later, but Trinity told people at first when this first occurred, she had said that the child had fell off the bed. She had actually mentioned that the night before, talking to Mr. Hermont.
Objection,
Through-
Your Honor. There's
Let me, not told, but said through text message.
facts, not in,
Through text message, I take it back. Through the text message. She didn't tell in the sense of talking. But you'll see on the text message from Ms. Hermont where she said that the child had fell out of the bed the night before. And you'll see that she said that then. And so then you have not only her statement that happened, but I brought two witnesses in to talk about they heard a baby crying sometime between midnight and 1 o'clock or so, loud enough to wake them up. Now, these weren't even particularly favorable witnesses to me. They had some things to say that weren't all that favorable for TrinityPoague, but they were important witnesses because they established when she said something happened that night, that he fell out of the bed. Well, you got two witnesses that said, well, I'm right across the dorm, one straight across and one to the caddy corner, and I heard the baby crying enough to wake me up. Now, they both said the baby would cry a lot of different times for various reasons, but this was enough to get their attention. So we also know that happened. Now, she did say, when some of the records will show, there was a claim, if you remember, Dr. Wright, or Reverend Wright, I should say, said that she claimed that the child was in distress and fell out of the chair. Talking about that little pink chair. Well, if you look at the pink chair, you'll be able to quickly see she fell out of the pink chair and nothing happened. I would suggest to you, and I believe that I asked him about it as well, that what she meant by that is when she noticed the child in distress, the child was slumping over, and it just sort of slumped out of the chair. That was not the cause of the injury. She was not presenting that to say it was caused by the child falling out of the chair. She was telling them, what do you know? Well, I came up, the child's in distress, and it fell out of the chair. She wasn't insinuating. There were two different things here. Two different things entirely. I had lots of questions I was asking about possibilities of falling out of a bed, and I know that some of the experts try to discount that to some extent and want to say, well, we're not talking about it, time may not be right, or I don't think that injury could occur. 40-inch bed is pretty high. 40 inches as high as my hips. You're talking about a small child that's 31 inches tall, falling onto a hard concrete floor. That child lands flat, bam, the back of its head, and have some significant injuries. But I asked Dr. Clark about it, and he was kind of waving around, but then I asked him, remember, about particular scientific journals and treatises. And he didn't know I was going to ask him about it. I didn't know that he would know what I was talking about, but I asked him if he was familiar with Mary Case, Dr. Mary Case. She's a forensic scientist out of St. Louis County's forensic department. I said, is she well known? Yes. Do you know her? Yes. And I said, how do you know her or whatever? And he said, oh, I just went to a seminar, a week-long seminar with her. I've been to two. You could tell. He valued her opinion. And I brought that up because I wanted to point out a fact that was contained within that particular literature. And there was a particular page I turned him to. And I'm going to read you about that page one more time because I think it's critically important. The paper was talking about accidents in which children had fallen from not particularly large heights, and it was severe enough that it killed them. And admittedly said it was rare. It didn't happen all the time, but from time to time, a fall would occur that would appear that wouldn't be enough to cause significant harm, but did. And the first case study said that a 4-month-old male child was taken to a children's hospital. They did a CT scan, and it came back normal. He would not eat or sleep well. He survived for 2 days. They would then decide to take him to see his pediatrician. He died on the way there. They said he fell out of an adult bed and struck the edge of the bedside table. So an adult bed, unless it's something really unusual, would not be even 40 inches tall. A second one said a child that was 21 months old, male. He cried after he had fallen. He was able to be comforted. He vomited, but then put back to bed after he was through vomiting. They found him dead in the bed the next morning. He had fallen out of his own bed. A third one was a 7-year-old female who fell off of a 36-inch tall tree stump, and she hit the back of her head. She complained of headache and vomited several times. Over the next 12 hours, she's found dead the next morning. And then finally, a 10-year-old boy who had fallen off his bicycle, and he was found on the ground. He went to the emergency room. CT showed a fracture of the right temporal. Then it cuts off as to what happened, but he died. Now, these all involve subdural hemorrhages. Now, the expert, Dr. Clark, wanted to try to walk away from that some by saying, well, wait a minute, those deaths weren't caused by a fracture back here. They were fractures somewhere else in the skull, so that just sort of didn't count. Well, one of them did involve falling on the back of your head, but regardless of whether they were the exact same fracture, it's pretty good proof that at time to time, a fall from not too high can cause significant injury. And if indeed that fall from the bed caused that, and sometime it can't be discovered right away, and you looked at it, you see these examples, no one thought these children were in great danger. Two of them went to the doctor, hospital, and were given the clearance to go home, and they died. This young lady here, TrinityPoague, she's not a doctor. There was no real visible signs, even according to the doctor, to the officers that first looked at the child. There was not in a real heavy area of what might be considered harm, where you would look at the child just visually and think something serious was wrong. In fact, even the autopsy doctor said, and the doctor at the scene of the ER said, you had to feel the back of the head to realize that it suffered any injury. If that child got injury out of the bed at around midnight or later, it may have taken a few hours before it all of a sudden erupted and showed itself. TrinityPoague had no reason to think that was any serious injury. She would have no reason to. And she certainly would not have been the person that caused it. And if that's a possibility, and it certainly is a possibility, there's enough evidence to show that that most likely did happen when a child falling out of the bed. That's reasonable doubt as well. You cannot say that TrinityPoague was the cause of it. And I know, ladies and gentlemen, that you've heard some other things that you may have questions about TrinityPoague's posting of certain text messages that are in evidence already. She was in an immature relationship at 18 years old with a 23-year-old man, and she made comments from time to time as they went back and forth with their up and down relationship that could have been said better. And she did say at times she did not like the child and those type things. But never once has anyone said that they saw her in any way trying to in any way harm that child, including the father never said that. He never claimed that there was anything abusive going on. These were a matter of speech. It's much like if my wife were to go out shopping and come home and I thought she was buying a $100 coat and it was $1,000, I might call one of my friends and say, I could strangle my wife. She just bought a coat for $1,000. Do I mean I'm going to strangle my wife? Of course not. Poor language perhaps, but just simply talking, in this case, mostly to Miss Permont, who is her roommate, who is a person that she is very close with, who that she discusses her relationship. In fact, you will see in this thread of information on the text messages, you will see where in parts of this, Miss Permont sort of agrees with her on stuff. She's talking about having trouble in State's Exhibit number 39, and she asked, is he sleeping with J.D. in your bed? And Trinity replies, probably. And she says, TRIN, that's so messed up. Make him get on the air mattress with his child. That's not your kid, and y'all aren't together. I know I told him after the night he better not contact me, was Trinity's reply. This is a conversation between Permont and Trinity. So we know a few things from just that little thread. First of all, Miss Permont's saying to her, you need to quit letting him just give the child to you while he goes and sleeps and does whatever he wants to and won't tend to the child. It's his child. Tell him to come be responsible for getting him into bedtime and doing what needs to be done. So she knows that that's been an issue. And then secondly, offers her a place to sleep, and she says in return, though, after the night, better not contact me, let you know it's on that downswing again. That's what I was talking about just a moment ago. And then there are conversations after that. But this is not proof at all of any type activity by TrinityPoague toward that child. You know, you don't have any evidence that TrinityPoague made any type of confession, which of course she did not. You don't have any evidence that she talked to some people after this event and has told them incriminating evidence somehow or another and they brought it into court. Again, you have no evidence that says she committed this crime. You have the suspicion that she committed this crime that is given to you by the district attorney and then by the state of Georgia without evidence to support it. Now, you also heard that she searched some items after she was at the hospital about skull fractures on her phone. And I want to be very clear so there's not any confusion about this. This is not a search that was done before the child had been injured. This is not a search that was done during injury of the child. This is a search that was done after she was at the hospital and after Dr. Busman met with her and Mr. Williams and told them that the child had a severe skull fracture and was likely not to survive. Now, at that point, you can look at this, and I'm going to tell you where to look on this as well, because I think it is very important that you see this as well. On those same documents, the one that's 1 through 39, the medical records, if you look at page 38 of 39, it has a colloquy that shows at 1:15 that afternoon, he spoke to the family to update the condition. That is when they meet and say, this is really serious. TrinityPoague, an hour or more later, and then 3 or 4 hours later, did search terms about skull fracture. And what does that mean? And how can a child have a skull fracture? That's very logical to assume you would do that. If someone told me my child had a skull fracture and I had seen nothing happen to cause anything to injure to the head, I would want to know, how can that be possible? And I might even say to myself, well, I know he fell off the bed, not that high of a bed, but is it possible that he fell off the bed and it caused it? And I would search. And that is what happened here. This is not, again, the way the prosecution wishes to portray it. They want to try to make it some nefarious, evil thing that was done. She did the thing that anybody would do. Check and try to find out what in the world does all this mean. TrinityPoague was 18 years old. She was living alone for the first time in her life at Georgia Southwestern College, and she'd been there one semester when all this happened. She came to the hospital after a traumatic event happened that she had no idea what was occurring on a child that was in distress, on things that she had nothing to do with, and did not know what was occurring. And then found herself within an hour or two being interrogated by GBI agents, by police officers, all that you can imagine, and her trying to figure out what in the world is going on. Now, ladies and gentlemen, you've been sworn in to follow the law in this case, to make a decision on whether or not the state has a right to say that she committed a crime, a serious crime. And your duty is to hold the state to their duty, which is they must prove that case, each and every element, beyond a reasonable doubt. If any doubt exists whatsoever that is reasonable, you cannot convict. You cannot discount the possibility that Mr. Williams could have been responsible. You cannot discount the possibility that an accident happened to the child while they were showering. You cannot discount the possibility that the fall from a 40-inch bed caused injuries to this child. All of those are reasonable doubt. You cannot come back with a verdict otherwise. You know, this place that I'm in today, I've been practicing law now for longer than I sometimes want to admit. And I've had many a trial, but it never changes in one respect. When I'm in a courtroom, this is hallowed ground. Where I am at right now is the bedrock of what we do in this country. We're a country different than all other places, in that we require, when someone is accused of a crime, that it be brought before a jury to make a decision, and that the proof of it is not just, I think you did it, might do it, more likely you did it, but you must have solid, no question evidence beyond a reasonable doubt. It requires that to be evidence. There's not been evidence at all. The state still doesn't know how it happened, where it happened, why it happened, who it happened, or even with what was used for it to happen. Do not make the mistake of allowing your emotions to be involved in this case so that you say, we must have a verdict some way because a tragedy occurred and I need a verdict. Do not, as I said in the opening of this case, in your rush to seek justice, do so on the cross of innocent blood of Trinity Poague, who has not had a thing to do with the injury that occurred to that child. It was a tragedy that occurred for reasons that I will not stand here and tell you I know the reason. But the interesting thing is, they don't know either. Oh, they know it's a death, they know it's blunt force, but for all the reasons I've told you before, they do not know. I trust you when you go back to the jury room that you will consider the law, you will consider the evidence, or in this case, the lack thereof, and you will return the only just, the only righteous verdict, that Trinity Poague is not guilty.
Thank you, Mr. Chairman. I'm going to give you a 15-minute recess. We'll come back at 12, let's make it 12:10. We'll come back at, not 12:10, I'm sorry, 11:10. 11:10, we're clear on that, 15 minutes basically. Thank you. Probably. I mean, we'll see how it's going.
I just want to if I get to that point where it just feels like that might not be a bad time, just jump in from.
No, I'll let me just deal with it. All right, Mr. Lamb, you can conclude your argument.
In the way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who had become a drug lord in Miami or whatever in the 1980s, and there's a scene in there where he gets caught. Not for pushing drugs, but he gets caught for laundering money, like trading money for the swapping it out with somebody else for percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. And so he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not idiot. And the lawyer looks at him, and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey, baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Gamble's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things he created, and that's why, literally why, I ask you, so when you listen to this, nitpick, wait for an answer to this question. What do these things really have to do with the death of this child? And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay, and I'm sort of starting actually. I think I'm starting kind of in reverse. I should have gone back and put them in the order of the indictment. But there's a reason that I wanted to do them this way, and that is that I wanted to start with what's kind of the underlying felony charges, which then go up the scale as you add other things. So aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body, which the evidence in this case establishes that J.D. Angeli's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice, or the word maliciously, and the law. And this is what I think Judge Sizemore is going to charge you with all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with you. And if you don't, if there becomes a question and you think we need to be clear on this point of law, all you got to do is say, hey, Judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, whatever, with the degree of force that's necessary to fracture this bone, with the degree of force, in a separate blow, with a degree of force that is sufficient to tear his liver practically in half, okay, then you know, folks, that's malice. I mean, because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that it is a strong likelihood that pain is going to result. So if you find TrinityPoague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges, if you do, then that brings you to felony murder. And what felony murder is it says a person commits the crime of murder when in the commission of a felony he causes the death of another human being with or without malice. Okay? So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right this minute. Kind of thing. Don't have to prove that, okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony was intentionally committed with the person knowing that it was likely to cause pain. And if you do, then that leads to the finding, I think almost necessarily, I say I think and not I think, but I don't, there's, when you look at it, how do you analyze this? You find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here. And that circles back to where we were at the beginning of my first part, which is that the question is who caused the trauma that killed the baby within that time frame? I mean, that ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it, and he's absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. She had it when she came in this courtroom, okay? She has it when you go to the jury room, okay? But when you look at the evidence, and you find that the evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is not it's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in Colquitt. JD was with him. He had been up here. He'd been up here earlier in the week. He'd stayed here like Thursday night, Friday night. Okay, he had stayed at her dorm, or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He'd stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay, she said, because they're breaking up, she's breaking up, right? So she wants to leave, she wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies and says, I was in a wreck. And he told you that, of course, his reaction to that is he took off to the campus, to check on her, and she wasn't in a wreck. She wanted to talk to him. And so it was sort of reverse stalking. Like, instead of following somebody, he said, here, come here and follow me. And that's exactly what she did. And so on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asks him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere is because he was going to be home with his son, with JD, and nobody else was there. His sister wasn't there. Didn't have anybody else to keep. Didn't trust anybody else to keep JD, and so he tells her, he says, I'll come, but I've got JD with me. And she says, well, come anyway. Just bring him with you. They get there, they eat dinner, they go to Sephora. She swaps the car seat from his car to her car because it says that according to his testimony, she says that it would maybe give her a little time to spend some time with JD, while she's driving and work on building some kind of bridge or relationship with him, etc. So then she says she wants him to come back to Americus with her. And the car seat's in her car already, and he says, yeah, okay, I'll come back to Americus with you. Okay, so at this time, when they're in Albany, okay, this video is from, it's one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car, okay? This is when Jay Williams has left Colquitt and is coming to Albany, that this video is taken, okay? And he's wearing his little his black Nike is what I'm trying to say, his black Nike hoodie and not hoodie, jacket and pants, his suit, tracksuit or whatever, which is the same thing that Jay Williams was wearing himself. He made reference to it that was they had matching outfits. Okay, this is what this child looked like. Okay, there's no bruise on this side of his face. There's no marks on this side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now there are these claims that were made in opening statement, okay, that have turned out to just simply not be true. Okay, in opening statement, the defense says that Jay was drinking when he met her in Albany, and she just couldn't send JD back to Colquitt with him, so that's why she took the child, and then she let them come to Americus with her because they wanted, they wanted to go to Americus, or Jay did. That's what you were told you would hear. There's no evidence that says that. There's no witness who testifies to those things that you were told you would hear. In fact, what happens is on January 13th, if you look, after she has asked him to drive from Colquitt, from Albany to Americus, okay, before she's even back at the dorm, she texted Paris, and she says, "Are you coming back? I got stuck with JD." Paris says, "Yeah, I'm coming back." And she says, he made me feel so bad because it's already late and JD is being so fussy. So he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense at all that he would have done that, because if he's in Albany, he'd be closer to home than he would be to here. So on on Saturday, then what happens is this. They get to the dorm, they go through the doors, and you saw the video from Georgia Southwestern. They go through the doors at 10:06. He testifies that he blows up the air mattress for Poague and JD to sleep on. TrinityPoague and the baby are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context of some of the other messages that we'll get to later, and I think the testimony of Paris in this trial suggested that typically when JD was here that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit them. Okay? She wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender. He wasn't shy. Wasn't any of those things, okay, because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and think at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. JD isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with JD. So they go Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. She had gotten into bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and he put him on the bed with them and he laid him on his chest for a little while and whatever, and then they got up to take a shower. Okay. Now, the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower. The testimony, and you will recall it, of course, was that they had talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later. And whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut, and at the time he left, and at the time TrinityPoague got out of the shower and went back in the room, JD was in that pink chair watching Katuri, a kids show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay, so when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry. That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said as he was parking, he was about to get out of the car, she calls back, and she's not talking to him. She hears him saying, JD, JD, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them back there. But if you should decide that you need to see them again, all you have to do is ask, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and frankly didn't testify real clearly as to what she said in response to that. We said what's wrong, but he wasn't waiting around to find out. he put the pizza in the bags down, put the pizza down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went in with JD. The nurse met him and put JD on a gurney, and then he followed them to a treatment room. Now, Alan testified. So there's this thing that Mr. Gamble keeps making a big deal out of. It says that this note in the nurse's record. He says this note says that the child is limp and pale, that father present at bedside states child fell around 5 minutes prior to arrival. Okay? And that note has a time, an event time of 12:36. Okay? So Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in. That he was standing at the child's bed when he told them that. And folks, there's other things in this note that we know it's not exactly accurate. It's close, but it's not exactly accurate. Okay? The note says that the child is in ER, and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who was unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after when he came in the door, went to the front desk or whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that you've heard. He followed them to the treatment room, but Alan says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all of those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place that they'll let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay? By the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Bussman told you that. But he wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay? The note's written 8 hours later, and despite everyone's best efforts, okay, it's very hard to separate all of the scurry of events that happened over the course of, just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in there 3 times that he said that. He didn't tell anybody anything 3 times, okay? The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note, okay? It's simply copied into the record, because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and they get cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, that they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter, okay? And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital. And the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night. Alan wants to talk to him. Alan said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Alan asked him to go out and walked outside with him. And Alan asked him to go outside, and he does. he told Allen, according to Allen, he told Allen that Poague had told him that J.D. had fallen out of a chair. Poague got there, and she told Allen that J.D. had fallen out of the chair. She specified it was one of those round beanbag, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay? That's what she tells Allen, not what Williams tells Allen. I mean, it's the same thing Williams told him, but it's not. But it's not his words; it's her words. Okay. You know, there's a reality to what we do that when people go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line and word by word, second by second, minute by minute. Okay, I need you to tell me what did you say and what did they say next. You know, and then we come into court and we have these, you know, these prior statements, and you know, we've got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, you know, did you say that? Yeah, I said that. You know, I mean, and they know people. Somebody knows they said it. They know they said it at some point back there. You know, if you ask me, you know, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say, yeah, that's what I told him too. You know, because it's kind of hard to delineate those things, and that's just the reality of the memory. Okay, that's the reality of the memory, whether you're in a courtroom or, you know, you're sitting around, you know, on Christmas Eve with your family, and you start talking about something and say, you know, remember when so-and-so, and you realize that nobody there remembers it the same way you do. Okay? And you end up, you know, like you have, you know, people just like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so, I mean, the reality is that the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Allen what Jay Williams testified to, okay? What Jay Williams testified to, which is different than what Allen testified to, no doubt. Okay? What he says is that she was there and she told Allen in his presence, and that's where he heard the chair story from. In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who is promoting that story, not Allen. I'm sorry, not Jay Williams. I'll go ahead and address it now. I'll skip it later. He says, you know, but ask him, did you tell Samantha Ford that you knew, you know, did you tell her what happened? And he says, yeah, I told her. I told her what happened. I'm sure I told her what happened. And it's like, okay, well, what you know, what'd you tell? You know, did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair. Because that's what he told other people once he had heard it from her. But then he instead of getting the statement, the interview that that Ford had done with Jay Williams, okay, what Mr. Gamble does is instead of showing the interview and saying, look, you know, do you want to refresh your memory about this? Be sure that you know what you said. He doesn't do that. Okay, he's charging him with being able to have in his brain the knowledge of what he said in a 2 hour, I think it was an hour and 45-minute long interview on the day that his child died. Okay, so in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the America's Police Department sitting in waiting rooms or interview rooms. He spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Ford. Okay, so and said, did you tell her that without showing him the interview, without showing him the statement, without letting him, look back over it and say, well, I don't know what let me see exactly what I said in that 2-hour interview. And Mr. Williams says, yeah, I told her, fell out of the chair, because that's what he had been told, and that was the only information he had ever had about what happened to his child. He told Coroner Wright that Poague had told him that J.D. fell from a chair. But Poague also told Coroner Wright that J.D. fell out of the chair, that he was in a chair eating chips and then he was in distress and fell from the chair. She told Wright that Jay had been gone for 5 to 10 minutes at the time the fall occurred. Okay. That is the sum and substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. Okay? The court is going to talk to you about circumstantial evidence. Okay. What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old, and he's in a dorm room on the GSW campus, and there's only one person in the room with him when it happens, well, those are two direct facts, okay? Those are not circumstantial, those are two direct facts, and the circumstantial evidence is when you take those two direct facts and you make the inference, which is, under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay, and that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents, if it's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So you take those things into account, you think about it this way, you say, okay, now we know some facts, we know some direct facts. So what are the conclusions that can be reached from the direct facts? Well, I'd suggest to you that there's only two possibilities, okay? One is that it's accidental trauma, that's a possibility, or that it is inflicted trauma. Those are the only two possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not a realistic explanation, well, for a whole bunch of reasons. Okay, it's not realistic because you would say, how many times you fall off the bed now? How'd you get this bruise? And these bruises, and these bruises, okay? And they're not just bruises, okay? I'm not picking them up and showing them to you again. Right? But you saw the medical examiner showed you, where they looking at the scalp on the skull on either side, okay? There's brain bleeds here, and there's hematomas here, and here, and here. And then there's bruises here, and here, and here. And those things don't all come at one time. Those don't come from one fall. Maybe if you fall off the side of a mountain, and you roll 500 feet, bouncing every which way, you might bruise your whole body. Okay? They might occur in one event or at one time if you're in a car wreck, and there's one impact and you get impacted from every angle. But those kinds of injuries, it is not realistic to think that they could be the result of accidental trauma when there is such a collection of them, and they all occurred within the same within the same time frames. I think is what Dr. Clark's testimony was, that he thinks that those injuries, because they're consistent with each other, they're all new, they're all fresh injuries. Okay, the Dr. Oleg testified, like about the liver, for instance. She says that the liver, that you can tell that it's not an it's not a chronic condition, it's not something that's been going on, but you do that from the lab results, because you look at the lab results and the liver enzymes are they're not 20 times higher than they're supposed to be, or 100 times higher. Okay, the liver enzymes in one case are like 200 plus times higher than they're supposed to be, and the other 400 plus times higher than they're supposed to be. Okay, and the reason the liver enzymes are so jacked is because it is an acute injury. It is something that has just happened within a short period of time. Now, none of the doctors are specific about that injury or about the bruises. They're not as specific. They're not saying we can narrow it down to an hour, or within minutes or whatever, because, there is a broader range in which those things could occur. But when they are there, when they aren't there, and then suddenly they are, and when they are there, they are in the presence, or they're associated with, or in addition to an injury that can be timed or dated, then you know that they almost certainly occurred all at the same time. Accidental trauma talks about falling off the bed. The only evidence in this trial of a fall from a bed, okay, all of it, the whole total of all the evidence. Nobody was told by TrinityPoague at the hospital that fell off of a bed, that the baby fell off of a bed. Jay Williams wasn't told that he fell off of a bed. Okay, the police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said that he remembers, he said he didn't have a specific, he said he didn't know if there was a specific note, but he didn't remember for sure, if she said chair or what, but something about a fall. And he says, all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, okay, that are recorded by somebody else, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I can tell you that it changed significantly from the first time I talked to her to the second time I talked to her. Okay, so the only evidence of a fall off of a bed is this. I'm sorry. I think I skipped something here, but anyway. So you saw the message earlier, and I may have it out of order, and if I do, I'll apologize for that and try to do better next time. But you saw the text, you've heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says, he's okay, he's fine. Okay? So, not only did she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know. They won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know. I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed. I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell. That had to be it. And TrinityPoague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and in the next 2 text messages concerning that matter, TrinityPoague says, I don't know if he fell off the bed because I was asleep. Oh, and he just fell off of an air mattress. Rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier, okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night, okay? At 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those 2 videos that this screenshot comes from, but it's from one of those 2, either at 12:02 or 12:04, okay? Either, no, maybe more than 10 minutes after the child fell off the bed, but it is 5+ minutes since she sent the text saying he fell off the bed, okay? That is the state of J.D. Angeles, okay? And you saw the video in court. That's the screenshot, of course. And you look at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Oleg, okay, who's also not affiliated with the GBI or anyone else, I mean, other than her own practice, Dr. Oleg told you that there is 0 possibility that following this injury, the child could be doing these very things. The nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gilbert says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now, he works for the GBI. You know, he works for the crime lab, which is true, he is technically an employee of the GBI. He says, you can't trust Dr. Clark. You know, because Dr. Clark's going to say whatever they want him to say, I guess, you know, is what he's implying. It's not the case, okay? Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained, okay? And in those, he doesn't get called to testify because nobody's being prosecuted for murder, okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder, okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case. Well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay, issues a 6-page report, orders all kinds of stuff. Okay, comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live, in person, with his hands and a scalpel, findings were that this child was murdered. So of course they're going to call him. So Mr. Gamble says, you know, he says, but Dr. Clark ain't as slick as he thought he was. He says, because I got him good now. I had this article. He got an article. Let me see if I can find the article. Was that up here?
I don't know that it is. I think I gave it back because we couldn't send it to the jury, so I can give you a copy. Thanks.
It's all right. Okay. This is about the article. Dr. Clark said, well, give me a minute, let me read it. We took a little recess, okay? He read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off of an adult bed, died 2 days later of an epidural hemorrhage. You know, 9-month-old in, you know, Portland, you know, fell off of a table, you know, suffered injury, was taken to the hospital and they did not have any findings, died 2 days later from brain trauma. And Dr. Clark says, yeah, he says, I'm not only familiar with Dr. Case or whatever her name is, he said, I'm familiar with her. He says, I'm familiar with the article. I'm familiar with it. He knows the other doctor too that's cited in there, Mavo or whatever his name was. who she's citing. Okay? He says, yeah, I know these people. Okay? And I know this article, now that I've looked at it. He says, they're talking about epidural hemorrhages. Okay? An epidural hemorrhage is entirely different than a subdural or subarachnoid hemorrhage. And he explained on the stand, and I hope that you got it because, frankly, I probably didn't understand it well enough to try to repeat it to you. But basically, there's different layers between the, from the skull to the top of the scalp. There are different layers. There's the galeal layer, which is the fibrous tissue that's immediately attached to the skull, and then above that there's the dura and the something and something else, okay? And you can have brain hemorrhages, you can have hematomas that result, and they occur in different levels, and depending on what level it occurs on, it's subgaleal or subarachnoid or subdural or whatever. The article was only about epidural hemorrhages. And he said we had a very small epidural hemorrhage in this case. The significant ones were subdural, subarachnoid, and subgaleal. Okay? Article has nothing to do with the facts or the circumstances of this case. Furthermore, you go to the next section of the article, and it says that in almost all cases of subdural hemorrhages in a child, it is the result of abusive head trauma, which is exactly what it is a result of right now, in this case. How many times you fall off the bed? There's an occipital skull fracture, which is back here at the back of the head. It's a hard bone to get to. It's a hard bone to fracture because your shoulders absorb some of the blow if you fall backwards, and this part of your head absorbs some of the blow. And it's the thickest bone in the scalp, or in the skull, rather, the occipital. It's the thickest bone in the skull, he said. It's hard to crack, hard to bust, hard to split. It not only split, it not only busted the full thickness, the fracture went all the way through the occipital bone, but it continued into the up here, the parietal area. Okay? Now, Dr. Clark didn't call it a parietal fracture. He called it a separation of the lambdoidal suture, okay, which is where the two pieces of the skull come together over here, right? And the reason he called that is because it was on the suture line. Okay? But the sutures really, they all develop at different times. The sutures solidify, they they come together and ossify in the bone at different times in different children, different ages, and depending on where it is in the head, but it says this was bone. Okay, it was just on the lambdoidal line. Okay? The other doctor who did the x-ray, and this is what Jill Olick testified to, she said it's an occipital and parietal fracture, okay? But in any event, the fracture goes from here all the way up here. There's bruises on the face side in front of the head. There's a lacerated liver and a lacerated adrenal gland. He didn't have any of these conditions or injuries when he got to Americus on Saturday night. So did he fall out of a chair, right? That's the, we went from falling off the bed to falling out of a chair. And I will tell you the same thing that I told you about the other fall, because it's just as applicable. The nature and extent of the injuries cannot be explained by a fall from a chair, particularly not a fall from this chair. That chair, the part that you would fall over, okay, is only 13 inches off the floor, okay? So if you fell over that, the only way you could fall out of that chair is to fall forward. You can't fall backwards in it. Y'all, everybody here probably has seen one of these chairs or something like it before, I bet, and your kids probably have had one and all that, and it's a big fluffy, probably is kind of a beanbag thing. The cushion's beanbaggy, it's not a whole beanbag chair, but the cushion's beanbaggy. It's a big fluffy thing, okay, when you sit down in it, okay, the way it's shaped like a dish, you sit down and you basically sink into it, Okay? You couldn't turn the thing over backwards, you know, if your life depended on it, not from inside of it. Okay? And if you fell forward out of it, even if you were only 18 months old, if you fell forward out of it and landed right square on your face and busted your forehead and did this and that and knocked out an eye and all kinds of things, you still wouldn't fracture the parietal bone and you still wouldn't fracture the occipital bone. If the injuries cannot be explained by falls, the only realistic possibility is that this child was a victim of inflicted trauma. Okay? There's just not another explanation. I mean, it's either accidental or it's inflicted. And if it's accidental, if it's not accidental, it has to be this. And if it has to be this, if it's this, then it has to be by who is the question. Okay? So, Jay Williams, did Jay Williams inflict the trauma on this child? That's one hypothesis he offers. Okay? I was kind of stunned by this one. The other possibility he offers is, JD himself, he's active, climbing, growing, 18-month-old baby. He might have done this himself. There's no telling what he climbed up on and fell off of. I'm seriously, that's what he said. He said that to you. Like, you gonna believe that? Like this child, managed to come. Now, if somebody had come out of that bathroom where they were, okay, and the child had been laying face down, not breathing and unconscious and in respiratory arrest and with brain fluid seeping out of his mouth and his nose, okay, if you've been laying like that face down, on the side of the desk over here, and that was the only injury he had, sure as heck it could be accidental in that case. Yeah, it might be. But to think that the kid climbed out of, it's too dumb for me to waste any more time. I'm running out of time for me to just waste any more time talking about. A kid did not climb on anything and fall off and hurt himself. So, the only other option, the only other person is TrinityPoague. Now, I'll grant you that this case depends in significant part on the credibility of Jay Williams. It does. Every case has witnesses. Some witnesses are more important than others. Some witnesses are essential to a case. Some witnesses, are kind of interchangeable. You can use this one or that one or whatever to prove whatever you're trying to prove. Jay Williams is an essential witness in this case. Okay? But I'm telling you, when you assess his credibility, the judge is going to give you a charge about assessing credibility. Okay, like you consider their manner of testifying, their circumstances, how they would know the facts and circumstances that they're testifying to, their ability to observe, whether it's corroborated by other testimony. Okay, his testimony was corroborated by clear, undisputed evidence. Okay, there is a video from GSW that Chief Lewis played for you. Okay, that shows him walking out of the dormitory at 11:55, and shows him walking back in at 12:30, and shows him running out with a baby squeezed up against his body right here at 12:31. Okay, he wasn't there. Not only that, he said he was going to get a pizza. Well, how about this? There's a pizza, okay, right there on the end of the bed. Says he's going to Walmart. Well, there's Walmart bags, and there's stuff in the Walmart bags, and reach in, and you take it out, and you take a picture, and I'm not, so, well, there's Walmart bags. There's a receipt that says that these things in this Walmart bag were paid for at 12:14 p.m., okay? So if he left the dormitory at 11:55, and he's at Walmart walking out at 12:14, I'd say he's moving pretty efficiently if he managed to get there and to pick up items and get through the cash register in 19 minutes. But he did, okay? His statements to Allen and Mathis, okay, to Mathis Wright, I said Mathis, I should have said Wright, I'm sorry. His statements to Lieutenant Allen and Reverend Wright were consistent not only with what he told them, they were consistent with what Poague told them. Okay? They're consistent with what she told them about falling out of the chair, etc. Right? Big deal about the hospital records. Ladies and gentlemen, when you consider the credibility of this witness, I'm telling you, the hospital record does not disprove his testimony. It barely contradicts it. It barely, I mean, it's almost a, it's not a bump in the road. I mean, it's a pebble of sand that you walk over. Okay? The hospital record doesn't disprove his testimony. There's no one who comes in here and testifies and says, you know, this is what he told me. I wrote it down right here, word for word. I know this is what he told me. Okay? There's a hospital record that's assembled by a team of people who are working desperately to save the life of an 18-month-old child. Okay? And doesn't disprove anything about what he said. His GBI interviews do not impeach his trial testimony. Okay? And we'll talk about this for a second. I talked about it briefly a while ago, but I want to go back to it for just a moment. The GBI things, okay? What he... Pardon me, I'm sorry. I have to take a sip of this water. What he told Samantha Fort was that he didn't know what happened to the child. Okay? Now, defense counsel didn't play the interviews for you. He didn't refer him back to specific questions. He didn't refer her to specific questions to say, what questions did you ask him? Did you ask him what happened? He says, I don't know what happened. You know? She says, have you heard anything about it? Yeah, the only thing I've heard is what Trinity told me. You know? I mean, what Trinity told him isn't nearly as important in you know, for summarizing the interviews. Okay? It's not nearly as important in Jay Williams' interview summary as it is in Trinity's interview summaries. Okay? So, you know, he says, you know, well, what did he do? You know, what did he say? He said, well, he told me he didn't know. That's what he said. He said he didn't know. And it may very well be that without those questions being in front of you to know what questions were being asked and how they were being asked, that may have been the full and only and absolutely correct answer. Moreover, his trial testimony was credible. The guy sits there, you know, not showing a lot of emotion. You know, it's been 2 years. You know, you come into a courtroom, there's a lot on the line. You know, you're seeking justice for your baby. Okay, there's a lot on the line. And there's y'all, okay? And y'all are a wonderful looking group of people, okay? But I'd be scared to death too if I were sitting over here, okay? And I'm testifying, you know, and I'm asking questions, and Mr. Gamble's asking questions, and are all, you know, giving him the mean eye, you know, not kidding, you didn't really give him the mean eye, but you're all looking at him, okay? You're paying attention to him, okay? You're focused on him, and he knows you're focused on it, right? That is a tough position for somebody to be in. And you try to control your emotions because you don't want, I mean, anybody would. You try to control your emotions because you don't want to break down. You don't want to look, you know, like Jell-O on the witness stand, okay? So you steel up, you know, you tighten up, you say, okay, I'm going to get through this, you know, and you sit there and you do it, you answer questions cleanly, directly, okay? You answer them crisply, and that is the thing, if you think about, that you will recall from his testimony. That guy didn't evade a single thing, okay? He's not trying to dodge anybody's questions. He's not dodging, he's not ducking and dodging, he's not giving you this, you know, I don't know, I don't remember, that was a long time ago. You know, I mean, he's answering the questions the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. He's you know, at this point he's testified, okay? He's in the courtroom when this happens. And Mr. Gamble says, he says, well, about this jacket that the baby supposedly threw up on. Supposedly threw up on. Okay? So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where it's puked on? You know, well, sure enough, you have it back there, you know, and you look at it a little closer, and you see just how prominent that is, okay? It is all down, look, wrong side. It's all down this side of the jacket, okay? It's not only down this side of the jacket, it's inside the collar, okay? I mean, it makes my stomach weak just to hear that, okay? About, you know, I mean, listen, I love my children. I love them with all the world, okay? But my ex-wife was a nurse, okay? And when young'uns started throwing up, you know, okay, I do everything. I changed diapers, I cooked meals, I did all kinds of stuff, okay? When young'uns started throwing up, I'm like, Betsy, come here, you know, because I couldn't stand it, okay? It makes me puke for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital, and while he's doing it, this kid is puking on him, not on his clothes, not on the floor, not on the seat of the car, or in a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket, okay? He doesn't let go. He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un, look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're gonna mock him and say, supposedly someone threw up on his jacket. Come on. He was credible as to what he had testified to. And ultimately, ladies and gentlemen, there is this. He has no reason to harm his son. Now, Mr. Gamble says, you know what? They should have gone to Colquitt and talked to neighbors and friends and all this kind of stuff and asked about all that. And, you know, like they should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day. Right, and they take his phone. Okay, they do a search for his phone, a search warrant. You know, they snatch his phone too, not one, two phones. They snatch 2 phones from him. Okay, and they're investigating. But when they're the dormitory interviewing people, okay, they're not interviewing people to say, tell me what you know bad about TrinityPoague. Okay, they're saying, tell me what you know about this baby being in the dorm last night. You know, and then from there, you know, it may go on to other questions, but it's saying, what do you know about the baby being in the dorm? Left, gone, okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing, okay? And there's no reason for them to go to Colquitt, because I tell you this, okay? He's got an apartment in Colquitt, right? If this child had died in Colquitt, Georgia, on Sunday, January 14th, 2024, okay, and TrinityPoague had been there in Colquitt with him when it happened, you think they're going to be coming up here talking to people that live on a dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street. You know, and the people that he sees in the parking lot, the people that he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information. If this child had died of malnutrition, okay, if he had died as a result of, you know, septic shock for some wound that didn't get treated, okay, if there was a negligence case or something like that where you have a baby that just doesn't get taken care of, okay, where defects has been involved, all these kinds of things, if you have that, then sure, you go interview the neighbors, etc. Okay? J.D. Angeles died because something or someone smashed him in the back of his head and cracked his skull open, and then smashed him again and split his liver. Okay? He didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, you know, and the neighbors somewhere else didn't hear him. Okay? Nobody's aiming for TrinityPoague. Nobody's aiming for TrinityPoague. You know, hey, I'd rather have a different defendant, okay? You know, if it were me, right, if I got to choose who my defendant is, you know, I mean, I'd rather have somebody that looks mean and surly, you know, and is older, and somebody looks at him and says, oh, you know, he just looks terrible. That looks like a guy who would do this. You know, that's who I'd rather have as a defendant. Okay? Not an 18-year-old college student, or, you know, 19, 20, whatever she is. They're not after TrinityPoague. They're trying to determine how this baby died and who was responsible for it. Now,
Mr. Lamb, it's been a little over an hour, so I'm going to let the jury have a brief recess. We're just going to make it a 10-minute recess. And then we'll let Mr. Lamb conclude his argument. Okay?
Thank you, Your Honor.
Just before 12:30. bringing a copy of the charge. Aggravated battery, not cruelty to child in the first degree. Y'all see that where I changed it. It only, I know that. That's why when we only addressed aggravated battery, that didn't sufficiently cover it. So
Okay, thank
I changed it. Okay, let's bring the jury back in. All right, Mr. Lamb, you can conclude your argument.
Talked about Jerry Williams said that, you can see by the way, not only his demeanor in court, but the things he did, his actions, the way he came out of the dorm holding that child and all that. And, to my knowledge, no one had ever asked. I certainly had never asked until it came up in this trial. But then he testified to it. I said, so we're talking about your jacket, and they're talking about why we didn't collect the jacket to test for vomit. And he says, well, I guess you still could. And so that's what we'll put him back up on the stand later, if you'll recall. And I said, so do you have the jacket? And he says, yeah, I've got it. But where is it? Is it home? He says, I said, what's it? He said, I never washed it, the shirt either. They're there. I said, well, why hadn't you washed it after 2 years? And he said, because it's the only thing, that was the last thing I have left from my baby. Okay, that guy is not going to beat this youngin to death. Okay, Gamble's giving you a 5-minute window in which, I'm sorry, that hand I heard on the table saw, and it looks funny to me when I hold it up. He's not going to give you, he's giving you a 5-minute window, okay, where he says it had to happen. That Jay Williams could have done it. He could have done it in this 5 minutes while she's in the shower. Never mind, they're still in the same damn dorm room, okay, but he says he could happen in this 5 minutes that she's in the shower and he's out there with the baby, okay. There is nothing about Jay Williams that would lead you to believe or support the conclusion that he would have done this to his child. Who had a motive? If you could have a motive, right? Like these cases are hard, okay? I think Mr. Gamble may have misinterpreted me when I said that this is easy. I'm talking about, that element of the decision-making process becomes easy when it gets to this kind of a case, okay? But these cases are hard because these are the cases where every jury is going to give every defendant the absolute most presumption of innocence and the most benefit of reasonable doubt ever, because in your heart of hearts, like every other living, breathing human being, okay, you don't want to believe that somebody could do something so terrible to somebody so innocent. Okay, nobody wants to believe it. Right? So if you get past that, ladies and gentlemen, in your deliberations, you get to the point where, you know what, I believe it, okay, you've passed the reasonable doubt stage, okay, because you're giving her anybody else, you're giving anybody in this position, because you don't want to believe it. Nobody wants to believe it. So how do you make yourself believe it? How do you accept that TrinityPoague could do such a thing? Okay, yeah. So did she have a motive? She resented and ultimately despised that little boy. Okay, now you know this from her statements, her text messages, etc., starting back in August of 2023. All right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone between her and TrinityPoague. He started the back and moved forward because that's the way they're stacked up here. And she says, I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning. Okay, then she's talking about getting in the shower, and she puts him in there to wash him in the shower, and he gets water spraying on his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, I'm trying to take a shower, and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him. Okay, I'm not going to baby a baby. When she was talking about Jay Williams, I'd say, I don't blame you, girl. I wouldn't baby him either, right? Grown person. She's talking about a little kid. She's talking about a kid that stands that tall, okay? That's unsteady on his feet still. And she said, I'm not going to baby him. The witnesses that came and took the witness stand that were called by the defense said, oh yeah, she didn't like that young man. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her. She sends more messages. In August 17th of 2023, she says, why do I feel anger towards JD? When we were in the bed and JD kept touching Jay's face, I almost cried. Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, what do you mean? Like you feel anger towards JD? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laugh my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love JD the same as mine. But since me and you have gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is. But just seeing him makes her angry. In December, she sends a message, and yeah, I'm going to come back to it. Let's go to January. The day before, the night before, he was murdered. Says, what are y'all going to do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that in fact that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the in the bathroom, and she didn't realize he was behind her, and she opened the door or the drawer. I don't remember which one he said. But she opened it up and she hit him in the eye. Hit him in the face. She said, I felt so bad. I felt so bad. Okay? Where is JD when he gets the blow to the face? Okay? With TrinityPoague and nobody else. He ain't with his daddy. He's with TrinityPoague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much. But letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know. I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified of her. You heard those people that said he cried and cried and cried when she was there, and he would stop crying if somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I'd submit to you that basically the same thing is true of an infant. Okay? You don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures, I'm sorry. If you're not that person, okay, and little kids know, okay, they know, it's like, they're not going to go to that guy, they're not going to go to that girl, they don't want any part of her, okay, and there's these things that have happened, and they happen when he's with her, okay, and in this case, ladies and gentlemen, this is really important, I'm going to try my best not to run out of time, and I'm sorry, I didn't mean to talk this long. In this case, he says she hasn't given any confessions or anything, like they don't have anything on her. That's what Mr. Gamble said. I wouldn't have said that. Couldn't say that if he hadn't said it first. There's not. He's right. There's not. Okay, but there are implicit admissions that this case happened under her care, under her eye. Okay, there are implicit admissions that this happened. One of those implicit admissions is that she lied about what happened. Okay? The second one of those implicit admissions is that she changes the story. She creates essentially two separate events in talking to two separate sets of people to explain it. Okay? Third, she sends the text when she's at the hospital, and she sends the text to Paris. She says, I babysit all the time, and nothing like this has ever happened. Okay? Okay. Now you parse that statement, and you think about what that statement means. Okay? If I say, Stephen Douglas drives my lawnmower all the time, and nothing's ever happened to it. Okay? Until now. Right? I'm basically blaming Stephen Douglas. Okay? I'm saying this is different for Stephen Douglas. He drives my lawnmower. He doesn't normally break it. But he did this time, okay? If I say, if he breaks my lawnmower, okay, but I say, I've had this, I have had this lawnmower for years, and nothing's ever happened to it, okay? And then I turn around and say, it's an implicit admission, and my analogy may not be very good, but I think that you get the point, okay? That if she wasn't involved in this, if she didn't do anything, then the answer is, I don't know. Not he fell off the bed. Not, oh, no, it wasn't off the big bed, it was off the air mattress. No, it fell off the chair. No, it didn't fall off the chair, slumped over in the chair or something. Okay? I don't know is the answer if you don't do something. But if you do something, you're trying to explain it, or trying to absolve yourself of attention and criminal responsibility, then you come up with other things and other people to blame, etc. All right. I've left this part for near the end, and that is talking about this offense, malice murder, okay, which is a separate charge than felony murder. Person commits the crime of murder with malice aforethought, he causes the death of another human being. Okay? The court is going to charge you, I think, that there's two kinds of malice. Express malice is a deliberate intention to kill, which is manifested by external circumstances that are proven. Implied malice is when there's no considerable provocation and circumstances show an abandoned and malignant heart. Okay? Ladies and gentlemen, there is implied malice in this case. There is implied malice. Okay? Now, I will not tell you, and the judge is going to charge you. Okay, he's going to tell you that we don't have to prove Nobody has to prove because foreplanning, that they were premeditation. We don't have to prove premeditation. Okay, that's not part of the burden of proving malice murder. He's going to tell you that malice can be formed in an instant, and in an instant, a mortal wound inflicted, and it's malice murder. Right now, the reason that I'm bringing this to your attention is because you could reach the conclusion from this evidence, okay, that she either just lost it for whatever, that he left her with the baby again, he's going to get pizza and drinks, she's already mad because the baby's ruining her weekend and all that, okay, and he left with the baby and the baby won't shut up, the baby was crying last night, half the night, she, had to get up and go to Paris's room till 2 a.m. and she's trying to play with the baby and wake him up, and now he leaves her with the baby again, and she gets out of the shower and he's crying and he won't shut up and she just flipped out, okay, and maybe she doesn't intend, I don't think, what I think doesn't matter. I'm not trying to prove and I'm not trying to suggest to you or make you believe that she looked at him and said, I am going to kill you, okay? Like I'm not trying to convince you of that, okay? But I don't have to convince you of that for you to find malice murder, okay? What you have to find for there to be malice murder is that there's no provocation and the circumstances show an abandoned and malignant heart, that there's just a point at which somebody just goes too far, okay? And when you use your hands or the edge of the bed or the edge of the desk or the floor or the wall or whatever the weapon was to cause this kind of damage, then the evidence is sufficient to show that she's guilty of aggravated battery and first-degree cruelty and felony murder and malice murder. Now, Mr. Gamble has made a big deal out of, as he should as a defense lawyer, about reasonable doubt. And he says, this is reasonable and that's reasonable. Okay, the judge is going to charge you that we don't have to prove doubt beyond all certainty or to a mathematical certainty. We don't have to prove guilt beyond all doubt or to a mathematical certainty, right? And we don't have to disprove every ridiculous hypothesis or allegation made by the defense. Like I do not have the burden, frankly, of proving to you that this child climbed up on the dresser, and did a high dive on the floor, of his own accord. Because he'd had one injury, not a whole panoply of them. Okay? I don't have to prove that. I don't have to disprove that hypothesis because it's not reasonable. It's just dumb. And when you look at it, you say, this is not reasonable. Okay? So if there's some hypothesis that he's tossed out there that I haven't addressed, that doesn't mean that I failed to prove it. You can take the evidence and analyze the evidence and say either this hypothesis has been disproven or not disproven, or this hypothesis is not worthy of attention in proof. When you consider the evidence, something else you take into account that there are two specific false narratives, okay? And these are not just arguments that are where somebody's off track on something, okay? These are false narratives, okay, that have been promoted to you since opening statement. In this case, I just didn't get to say anything about it until now. Since opening statement, okay, that the diaper, it's not said directly, but it is implied, okay, that the reason James Gibson threw away the dirty diaper when he was examining the trash out of the trash bin on January 14th, the reason he threw away the dirty diaper was because there was a defense motion to test it. He files a motion and we said, we don't have it. It's gone. When I had to come to court and answer for it. Okay, that's not what happened at all. Okay, Gibson, as you heard from his testimony, made an independent judgment. Okay, maybe he's even wrong. Okay, everybody's wrong sometimes. There's not an agent that's good enough not to make mistakes. There's not a lawyer, a doctor, a cab driver, a carpenter, or anybody else that's good enough that they never make a mistake. And maybe Gibson's wrong. I would stand by the decision he's made as his fellow agent has done, but it had nothing to do with an expectation or worry or fear that it was going to be tested. What he had to do, and the fact that it was photographed, unfolded and photographed, doesn't mean that he saw it as being of special importance, but he wanted to hide it, Okay? If he saw it as being of special importance and wanted to hide it, he wouldn't have photographed it. The photographing is like everything else was in the trash bag, and he told you, he says, I opened up chip bags and cups and wrappers and all kinds of things. Okay? He photographed everything in there, not just the diapers. Okay? The second false narrative, okay, is that Jay Williams isn't legally JD's father. And maybe he's not, maybe he is, maybe he's not. Okay? But that has nothing to do with this case. It is a fact, it is a reference that is not even necessary to have been made in any context or circumstance whatsoever. Okay? It is designed to make you think that these people, the family of this child, do not deserve the same measure of justice that somebody would if they could say, not only is me and my wife, but I've got 9 DNA tests to prove it. This is my kid. Okay? Can't do that, can't do that. Certainly can't do it now. Okay, I bet he'd love to have a paternity fight now. Love to. Say, yeah, I'll fight about it, and if I lose, I'll kiss him on the cheek and say goodbye. Okay? But he can't. Whether he's his father or not has nothing to do with anything. Petty contradictions due to different perceptions or memory lapses. And we talked about this before, and I'm not going to go into it much further. Okay? Somebody says, oh, look, this is what I said. And they said, no, that's what you said. And it's been 2 years or more, and they're in 2 different contexts and 2 different, 2 different eyes viewing things, or 2 different sets of eyes, and sometimes they don't see things the same way. Failure to find or recover a weapon or other physical evidence at the crime scene. He says it can't be a crime scene because there's no blood. Okay? Some crime scenes don't look like the Manson family has been there. Okay? Some crime scenes, there aren't walls full of bullet holes. Some crime scenes, there's not anything in the room that specifically points to it and says, a murder happened here. Okay? Why would he not luminol the whole room looking for blood? Because he had just left the hospital and the child didn't have any external injuries. Okay? There's no blood because he wasn't bleeding. Whatever happened to the injuries that he suffered resulted from blows and force that caused him to have internal injuries that cost him his life. There's no weapon. Well, that really ain't right. That's really not true. Look at here. You heard testimony from the stand that if you pick the child up, Clark said it, if you pick him up and you held him by the shoulders like that, and you slammed him down on a hard surface, and Clark said something like a desk or a chair, I think were 2 of the 4 or 5 things he listed. Well, see, there's a hard plywood chair, there's a desk, and there's another desk, and there's a bed, and there's other photographs in here that show the end of this bed, where there's a bed post about that big that sits on the corner of it. Okay, and the fact that I can't come in here and say we have a videotape of her, smashing the kid against that chair, or, hurling him against the wall or hurling him against the bed, and the fact that I don't have a video of it, he's going to tell you that that means that you can't convict? Come on. I do have a picture. So you can see the bed. They're like the corner at the corner of the mattress right there. You can see it's like a metal bed post that sticks out of the thing. Investigative techniques, not a reasonable doubt. Joint interview. Okay, Samantha told you, Samantha Fort, I'm sorry, I didn't mean to refer to her by first name. Agent Fort told you that she had interviewed Jay Williams twice for 4 hours. She had interviewed Ashanti Burr before as well. I don't recall what the specifics of that particular interview were. What I would submit to you is that if it made a difference that in the third interview after their statements had already been made and sort of nailed down and this is coming back for additional information, if it made a difference, then he would have played the interview and said, look here, this is why, they're in there together. This is what's messing up all these statements. This is what's causing the testimony or the evidence to be tainted. That it may be poor technique. Okay? It may be poor technique. It may be a violation of what you learned in investigator school to put 2 witnesses in the same room and talk to them at the same time for any period of time. Okay? but it doesn't create a reasonable doubt when that's not the evidence that the case relies on. Declining to order or obtain irrelevant testing, okay, the diaper, the vomit, oh my God, I can't believe we're still talking about this, okay? So the diaper, yeah, what's his name? Dr. Busman says, oh, yeah, you know, in this light, looking at a photograph that was taken under flash, you know, and then put on a computer, processed through, displayed on this screen, you know, which I'm sure has exact true color under this light, yeah, it looks red, you know, right? Like he's not trying to fool anybody, he's not trying to joke about it, you know. Does this diaper look like it's got blood in it? Yeah, it looks red from here. Okay? And then, he's right. I believe that you saw that the significance of that was lost on Dr. Busman. Okay? He didn't understand why anybody was asking about, a dirty diaper. Okay? The significance of it wasn't lost on me, however, which is why I came back and pursued other questions. He says, the state bent over backwards to get him to back up. No, I asked questions on redirect, which I'm allowed to do, which I'm authorized to do, which I'm supposed to do to clear things up, okay? And when I go back and ask Busman, what is causing? He says, it doesn't have to be blood in red, something red. Well, you know what? If you look at that picture, and I'm not going to try to scroll back through it because I'll lose my place forever if I do, okay, of that child in the car seat coming from Colquitt to Albany when they went to meet at Chipotle, and he's got a sippy cup, okay? It has a liquid in it that is as bright red as the top of this cabinet right here. Okay? He's drinking, a big cup of red fruit punch or whatever. Okay? So what if he pooped red? If it mattered, then it'd be a different story. But there's nothing to suggest that it mattered because there's no illness, disease, or any other process that could have ever been detected from a red poopy diaper that would have led to a conclusion different than this young'un died because somebody smashed him in the back of the head. There's a lot of audacity floating around this courtroom, okay? Jay Williams, okay, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. The world is looking at you, buddy. Jay, I can't believe this. That baby is only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. The drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, I bet you he'd love to have to take one now. Bet you he'd love to have to take one now, And if a trooper had seen him driving with a kid not restrained in a car seat or something, and pulled him over, he probably would have got a ticket for like reckless endangerment or something like that, and would have been prosecuted by whoever, would have had jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, it's my job to prosecute cases. It's his job to defend cases. He's daggone good at it. And, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things, and a law clerk and somebody from the clerk's office, and everybody's here for a reason. And, I did this slide and I left off the judge, and it's going to sound like I'm being a smart aleck in doing it, but I was. I just inadvertently, I looked up and realized it's like, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job. Okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says, you will well and truly try this case and a just verdict give according to the evidence. Okay, there's two parts to that oath. There's two parts to that job. Part one is to well and truly try this case. And good Lord, I mean, y'all been great at it. I mean, everybody's been here every day, you know. I mean, people like, nobody's like, hey, look at that juror over there. They look like falling asleep, you know, things that we deal with, or, you know, waiting, you know, day after day for people who are invariably late and you know, don't come back from lunch and, you know, don't take notes, all those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath. And that is a true verdict give according to the evidence. Your job is to do justice with this pagan. That is your job. To do justice. To do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the jury, speak to the community. Okay? They speak. They say things to the community. People look at a jury verdict and they say, wow, you know, like, man, in America, they let people off for that, you know. But they look at jury verdicts and they say, you know, this is the wrong place. It's the wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of like not leaving blood, you know, kill somebody with your hands, you know, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verdict? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, you know. We're going to require video. We're going to require videos and confessions before we will convict. You know, if that's the standard you want to set, ladies and gentlemen, that's the standard you set. As DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. J.D. Angelus was 18 months old. If you want to do them right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. A true verdict give according to the evidence.
Move that aside a moment.
Yes, sir.
Charge again. My plan is to give you the jury charge, which will take about 15 minutes, and then let you retire to the jury room. Once you elect a foreperson and begin your deliberations, I'm going to let you decide if you want to go to lunch and take a break. I'll give you some more explanation of that when I finish. Or I'm going to let you, we could even order out some pizzas or something like that and bring it to you. But I'll give you a little bit more about that in a moment. Can y'all move, Madam Bailiff, if you'll move that to the right or the left? Yes, sir. Just so I can see every juror. Thank you. All right. Ladies and gentlemen, well, we'll see if this works. Okay. Ladies and gentlemen, you are considering the case of the State of Georgia versus TrinityPoague. The grand jury has indicted the defendant with the offenses of malice murder, felony murder 2 counts, aggravated battery 2 counts, and cruelty to children in the 1st degree. I have previously read the indictment to you, and you will have a copy of it with you in the jury. Well, you have the original with you in the jury room. The defendant has entered her plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered by you as evidence. It is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. The defendant is presumed innocent, presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. And facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and any matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks by the attorneys, or questions asked by the attorneys. Where the parties stipulate testimony, documents, exhibits only, this is the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence of this case. And by the way, you will have this jury charge, or this written charge with you in the jury room, along with the indictment, your verdict form, and all of the evidence that was admitted as exhibits, other than the videos. The videos will be in the courtroom. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in the light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, then you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury, to decide. Similarly, the jury must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner in testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you are able to observe it. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given to you in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You would evaluate such testimony as you would that of any other witness. However, the defendant does not have to testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Sumter County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Now, this indictment has several counts. You will need to consider these instructions and the facts of the case and reach a separate and independent verdict with regard to each count. Count 1 of the indictment charges the defendant with malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. That the killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intent to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, then that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proven by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Counts 2 and 3 of the indictment charge the defendant with the offenses of felony murder. The state does not have to prove, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated battery and cruelty to children in the first degree are felony offenses, which I will define for you shortly. You may find the defendant guilty of felony murder as alleged in counts 2 and 3 of the indictment if you believe that she caused the death of another person by committing the felony of aggravated battery as alleged in count 2, or by committing the offense of cruelty to a child in the first degree as alleged in count 3, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Count 4 and 5 charge the defendant with aggravated battery. For aggravated battery, the state must prove the defendant maliciously caused bodily harm to another person by depriving that person of a part of his or her body, by rendering a part of that person's body useless, or by seriously disfiguring a part of that person's body. For cruelty to child in the first degree, which is the charge in count 6 of the indictment, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously with regard to cruelty to a child, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Now, by no ruling or comment that the court has made during the progress of this trial has this court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of the first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. I'll remind you, you're not to have phones in the jury room. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Now, as I mentioned, this indictment involves multiple counts. You should consider these instructions in reaching your verdict with regard to each count independently and separately. And we have provided you a verdict form with regard to that will allow you to express your verdict with regard to each count. So using the verdict form, for example, with regard to count 1, for example, of the indictment charging the defendant with malice murder, if after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Sumter County, Georgia, did on or about January 14, 2024, commit the offense in count 1 of the indictment, you will be authorized to find the defendant guilty of the offense, in which event, with regard to count 1, the form of your verdict would be, we, the jury, find the defendant, and you would check or X guilty. And then, on the other hand, if with regard to count 1, you do not believe that the defendant is guilty of the offense of malice murder, as charged in count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict with regard to count 1 would be, we, the jury, find the defendant not guilty, and you would, under count 1, X not guilty, or check not guilty. Again, you should independently and separately make such a determination with regard to each count of the indictment. Whatever your verdict is, it must be unanimous, that is, agreed to by all 12 of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Now, in just a few moments, I'm going to ask you to retire to the jury room. But again, do not begin your deliberations until you receive the indictment, the verdict form, and a written copy of these instructions and the evidence that will be presented to you in the jury room. As I mentioned, what I want you to do is once that happens, select your foreperson and either begin your deliberations, or you can start your deliberations, and if you want to take a lunch break, let me know. If you want to start your deliberations and have us order some pizza and bring it into you, we can do that because it's right around lunchtime. I don't want you to rush. If you'd rather go to lunch and come back, that's fine. If you would rather have lunch as you deliberate, that's also fine. Whoever the foreperson is needs to make sure that the jury is not deliberating unless all 12 of you are in the jury room. So if, in other words, if somebody steps into the restroom, you should suspend your deliberations, okay? Or if you take a break, you should suspend your deliberations. With that, I'm going to allow you to retire to the jury room, and once you begin, once you get the evidence, the verdict form, the indictment, and the instructions, you can elect a foreperson and begin your deliberations. Wait, we have 3 alternates. If you wait just 1 second. I've got it. Jacob Cromer, Johnny Lassiter, and Sadie Golden. You 3 are alternates, and we're going to sequester you separately. But all of the instructions I've given you about discussing cases and things of that nature apply. Y'all are not yet able to discuss the case or do any research or anything of that nature, even with each other, unless you're brought into the jury room. But I do need you to remain in the courtroom. We have a different room. Judge Rambo has a state court office over here, and y'all will stay in there and just remain available. Everybody else can retire to the jury room. All right, if y'all come up and make sure all the exhibits that are going back are ready. Mr. Lamb, if you. Well, first is there, Chet, if you'll grab that door, please. Is there any exception to the charge from the state, from the defendant?
No, Your Honor.
Okay, that'll be fine. Mal, if you'll help them gather and organize the exhibits to go out.
I don't think I put it anywhere. Stephen, are my exhibits all in? Are they, I mean, like, do I have any missing numbers, or should I have every number?
All right, we're off the record.
You should have every number.
Except for like the three.
Let's head back to Sumter County, Georgia for more of the closing arguments in the pageant queen child murder trial.
The defendant there, TrinityPoague. She was a former Georgia pageant queen. She's facing life in prison because prosecutors say that she killed her boyfriend's toddler son, this little baby you see there, an 18-month-old named JD. His real name was Romeo Angelus, and his father didn't find that out until he died.
Yeah, he was found unresponsive in Trinity's dorm room. Later died at the hospital. She's being blamed for his death. Let's go back into the courtroom now. We're listening to the state's rebuttal case.
How do you make yourself believe it? How do you accept that TrinityPoague could do such a thing? Okay, yeah. So did she have a motive? She resented and ultimately despised that little boy. Okay. Now you know this from her statements, her text messages, etc., starting back in August of 2023. All right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone between her and TrinityPoague. He started the back and moved forward because that's the way they're stacked up here. And she says, "I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning." Okay. Then she's talking about getting in the shower, and she puts him in there to wash him in the shower, and it gets water spraying in his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, "I'm trying to take a shower, and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him." Okay. I'm not going to baby a baby. If she was talking about Jay Williams, I'd say, yeah, I don't blame you, girl. I wouldn't baby him either, right? Grown person. She's talking about a little kid. She's talking about a kid that stands that tall, okay? That's unsteady on his feet still. And she said, "I'm not going to baby him." The witnesses that came and took the witness stand that were called by the defense said, "Oh yeah, she didn't like that young man. She didn't like him. She didn't like him." And not only that, he didn't like her. He didn't like her. She sends more messages in August 17th of 2023. She says, "Why do I feel anger towards JD? When we were laying in the bed and JD kept touching Jay's face, I almost cried." Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, "What do you mean? Like you feel anger towards JD?" She goes, "I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him." Laughed my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. "Ever since he's gotten here, Jay has not touched me. He's currently on the floor." Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, "I told you from the beginning I would always try to love JD the same as mine, but since me and you have gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is, but just seeing him makes her angry." In December, she sends a message and says, "Yeah, I'm gonna come back to it. Let's go to January." The day before, the night before, he was murdered. says, what are y'all going to do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that, in fact, that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the in the bathroom, and she didn't realize he was behind her. She opened the door or the drawer. I don't remember which one he said, but she opened it up and she hit him in the eye, hit him in the face. She said, I felt so bad. I felt so bad. Okay, where is JD when he gets the blow to the face? Okay, with TrinityPoague and nobody else. He ain't with his daddy. He's with TrinityPoague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much. But letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified. He says, I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified of her. You heard those people that said he cried and cried and cried when she was there, and he would stop crying when somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I'd submit to you that basically the same thing is true of an infant. Okay? You don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures,
Now, the prosecutor's there with that dramatic reading of the text messages. It's compelling to hear him and not an investigator reading those.
Yeah, and the old, the old dog thing, which we've all done. Like, my dog is a great judge of character, so if he's
This little
barking.
baby was always crying in her care, and she even knew that.
Yeah, I mean, it's not, there's nothing legal about it, but it's
Sure.
a great close to throw into someone's head.
It's all argument.
A juror,
It's
yeah.
not evidence.
Yeah.
Let's get to our break. When we come back, we will have more of this rebuttal. It should be wrapping up soon. And notice on your screen in real time, because we've been pausing things, the jury actually has this case now. 5 minutes. How long are they going to go? Deliberating the fate of TrinityPoague. Stay with us. You're watching Court TV.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8, 7 Central, only on Court TV.
All right, you see the clock ticking. The jury has the case against Trinity Poague. We're going to get the last bit of the final statements from the state, the rebuttal close. First, a quick check in Florida, though, where a child custody hearing took place earlier today for Anna Kepner's stepmother and her ex-husband.
Yeah, the stepmother, Chantel Kepner, she was married to Anna Kepner's biological father, Christopher, and they're in this dispute. She's in a dispute with her ex-husband over the custody of their 2 minor children. One of those children is the 16-year-old stepbrother of Anna, who is a suspect in her murder. That's according to reports.
Yeah, this, of course, is the cruise ship murder. And at that hearing, Chantel Kepner took the stand and spoke about the last time she saw her children before Anna's death on that ship.
At some point, did you discover that one of the children had passed away?
Yes.
And when was that you discovered that?
Friday morning.
Your child, did you see him that Thursday night as well?
Yes.
What time did you see him at?
Closer to 7. Just a little bit before 7.
And what was he doing at that time?
He was headed back to his room.
Do you know whether or not Connor was present in the room as well?
They all were headed back to their room, as far as I know.
All right, we'll have more of that coming up in the 2 o'clock hour, but right now, back to Georgia.
All right, those closing arguments that we've been watching in the pageant queen child murder trial for Trinity Poague. She was arrested last year after an 18-month-old, Romeo Angeles, was found unresponsive in her college dorm room, and she faces life in prison if she's convicted.
Let's go back to the courtroom now, the remainder of the state's rebuttal closing argument.
Okay, Jay Williams, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. You know, the world is looking at you, buddy. You know, Jay, I can't believe this. That baby is only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. You know, the drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, you know, I bet you he'd love to have to take one now. Bet you he'd love to have to take one now, you know? I mean, and if a trooper had seen him driving with a kid not restrained in a car seat or something, you know, and pulled him over, you know, he probably would have got a ticket for, like, reckless endangerment or something like that, and would have been prosecuted by whoever, you know, would have had jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, you know, I mean, it's my job to prosecute cases. It's his job to defend cases. You know, he's daggone good at it. And, you know, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things, and a law clerk and somebody from the clerk's office, and everybody's here for a reason. And, you know, I did this slide and I left off the judge, and it didn't sound like I'm being a smart aleck in doing it, but I was. I mean, I just inadvertently, I looked up and realized just like, I thought it said judge. It doesn't. Everybody here has a job, okay? And you have a job, okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says, you will well and truly try this case and a just verdict give according to the evidence. Okay, there's 2 parts to that oath. There's 2 parts to that job. Part 1 is to well and truly try this case. And good Lord, I mean, y'all been great at it. I mean, everybody's been here every day. You know, I mean, people like, nobody's like, hey, look at that juror over there. They look like falling asleep, you know, things that we deal with. Or, you know, waiting, you know, day after day for people who are invariably late and you know, don't come back from lunch and, you know, don't take notes, all those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath. And that is a true verdict give according to the evidence. Your job is to do justice with this baby. That is your job. To do justice. Do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the jury, speak to the community. Okay? They speak. They say things to the community. People look at a jury verdict and they say, wow, like, man, in America, they let people off for that, But they look at jury verdicts and they say, this is the wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of, like, not leaving blood, kill somebody with your hands, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verdict? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, We're going to require video. We're going to require video and confessions before we will convict. If that's the standard you want to set, ladies and gentlemen, that's the standard you set. As DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. Baby Angelus was 18 months old. If you want to do them right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. A true verdict given according to the evidence.
Thank you, Mr. Landis. Move that aside.
Yes, sir.
Charge it.
All right, that's it. And as you see, the jury has it now 17 minutes. They've maybe picked a foreperson, just getting into the deliberations. Philip Dubé, overall thoughts on the case as this jury decides Trinity's fate?
Yeah, it's a rough fact pattern because when you think about it, I mean, here you have a 4.0 honors student studying nursing, I believe, which is a little weird. You would think that she would first do no harm, particularly with the baby. So it's kind of incongruous, the act, if you will, if she in fact did this to the baby, with her future goals and objectives and endeavors. I mean, she could literally, with the stroke of a pen by this jury, go from being a crowned beauty queen to a defrocked killer. It's really unbelievable. And if that's really the case, then this young lady has really two sides to her. But on balance, it could go either way, frankly. And if she is convicted, I'm convinced it will be because of those sort of insensitive, if not offensive, text messages that she sent. It looks like that she had utter contempt for that baby. And I guess the jury would have to decide whether or not it would be a stretch to go from that contempt to a fatal blow to the baby's head.
Yeah, and even that fatal blow, even describing it, Philip, we don't really know what happened. Prosecution didn't really say exactly how she created those injuries. Real quick before we have to go to break, was it a mistake for her not to get on the stand and give more of an explanation?
Yes. I think she should have looked her jury right in the eyes and said, I did not harm that baby. As soon as he left and the baby was there, something appeared to be wrong, and she did whatever she could based on the limited information that she had, and unfortunately, they're fingering her for this, but that she's innocent.
And now we will see what the jury does with it. Philip Dubé, thank you for your analysis this hour. 19 minutes this jury has been added. We will let you know if they have a question or a verdict. Coming up, though, Court TV's Matt Johnson is going to join us to give us an update out of Massachusetts, the Brian Walsh trial for the death of Anna Walsh. We'll keep you updated on all of that and the death of Anna Cutter. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this afternoon as we begin this hour in Dedham, Massachusetts. Defendant Brian Walsh is standing trial on charges that he murdered his wife, Anna. Prosecutors say that he killed her back in 2023 and then spent several days trying to conceal the crime before she was ultimately reported missing by her employer. Now, her body has never been found. Joining us now is Court TV crime and justice correspondent Matt Johnson, who's there on the ground inside of that courtroom. Matt, good to see you. Tell me, what testimony is standing out to you today?
Julia, nice to see you. So week one on the books here in Dedham, Massachusetts, in the murder trial against Brian Walsh, and another key day with another important witness on the stand. Starting the day, we had Trooper Connor Keefe back on the stand. He's a digital forensic expert. He analyzed the cell phones collected from the Cohasset home of Brian Walsh, this defendant, and his wife, missing Anna Walsh. And he really testified about some interesting details, including some text messages allegedly sent by this defendant after his wife went missing. Take a listen.
3rd, 2023, 6:39 a.m. I'm worried. Please call or email.
What time was this sent?
January 3rd, 2023, 6:39 a.m. If I don't hear from you this morning, I'm going to report you missing.
What is the date and time this was sent?
January 3rd, 2023, at 8:32 a.m. Where are you?
And what is the date and time that was sent?
January 4th, 2023, at 10:14 a.m.
For the messages on January 2nd through January 4th of 2023, does any of the messages denote that they were delivered?
It does not appear that.
Now, on cross, the defense attorneys, they were focusing on and pointing out that in their opinion, there were no signs in the text messages, at least, or search history showing premeditation of murder. Take a listen.
It's fair to say that in the searches running from the date of December 25th of 2022 up and including the end of December 31st of 2022, you saw no evidence of searches in the Safari search history regarding any searches for things like tools or searches suggesting how to dispose of a body or anything like that, correct?
I did not see any of those December 25th to the 29th.
And I was looking over at the jury during that testimony. They were taking a lot of notes, Julia. They're very interested in the messages that were sent between these two phones.
Yeah, so many messages, all while the prosecution says Anna had disappeared, that she was deceased. Okay, so what else stood out to you today? And I do want to ask you about someone from the medical examiner's office on the stand, which I was surprised to see since we don't have a body in this case.
Exactly. There's a no-body murder trial taking place here in Dedham, but this pathologist was asked to look at and evaluate tools that were collected from dumpsters that are believed to be the items that were used to dismember Anna Walsh's body before she was disposed of. Let's also show you the video that was shown up close and personal that we just got in-house of these items that were shown to the jury in the jury box and what this pathologist had to say about those items on the stand. Take a listen.
Normally, we're not involved in examining items, just bodies of people. In this case, the objective was to determine whether there was any human tissue on these items.
Some of the women seated in the front row of the jury box, they were holding their mouths as they were seeing some of the items up close and personal, including that hatchet and that saw. Julia?
Oh, wow, that's so telling, Matt. They're not going to have to see autopsy photos, but those tools say everything, really. So that's the jury reaction. What about the defendant? What was he doing?
All right, so he left the courthouse just a few moments ago, and I was back there trying to give him an opportunity to answer our questions and make any statement that he wanted to. I mean, this is day 5 of this murder trial. He says that he didn't kill his wife, or at least that's what his defense attorney said through opening statements. But it has been a week of bad facts, including those items that were discovered in dumpsters, those tools, surveillance video of him dropping off trash bags at those dumpster sites, and then, of course, all of those search history that is very disturbing. So here's what he did or didn't say after court today. Take a listen.
Brian, how do you think the murder trial's going? Any message to Anna's family? Any message to your kids?
No message to his kids, no message to Anna Walsh's family, and no comment to our questions. He's back to jail for the weekend. Testimony has ended for the week. Testimony resumes on Monday morning, Julia.
Matt Johnson, that's a unique perspective to be able to talk to the inmate as he is going back to lockup. Of course, this courtroom's not unfamiliar to you. Can you talk about the feel there? You've been in Dedham for another big trial that you covered this year. What's it like in terms of the community when we're talking about this case?
Right, you know, there's a great big comparison here. It's nothing alike. Karen Reed trial that took place over the past couple of years here, trial 1, trial 2 I covered. I mean, the streets, they were blocked off with state police officers keeping the peace. There was a buffer zone in place. There was also supporters and protesters here out on the courthouse steps in Dedham, Massachusetts. We're not seeing anything like that. We saw a lot of media from across the country on day 1 during opening statements. There are a few stragglers still there. We're here each and every day for the duration of the trial. As for the community, there are no community members in the gallery. There are no protesters or supporters out on the courthouse steps. But in the town of Cohasset that I visited after this crime took place, after Anna Walsh went missing 3 years ago, they were in shock, and they were just hoping to find a resolution and hoping that she gets found.
Such great insight. As always, Court TV crime and justice correspondent Matt Johnson, thank you for that report. We are turning our attention now from Massachusetts to Florida, where details surrounding the death of an 18-year-old teenager, Anna Kepner. It's being revealed in a child custody hearing that doesn't have to do specifically with her death. Chantel Hudson Kepner, who was married to Anna Kepner's biological father, she's in a dispute with her ex-husband over the custody of their 3 minor children. Remember, this is the teen who mysteriously died on a Carnival cruise during a time with her family, a blended family. Now, one of those children of the Kepners is a 16-year-old stepbrother, and he has reportedly been a person of interest and suspect in her murder, has not been charged or arrested. And before we take you into court for that child custody hearing where a lot of these details are being revealed, let's take a look back at a closer look at the victims who are at the heart of this case.
She was a great woman.
She always wanted to make people laugh. She loved the water. We were constantly going to the lakes here where I live.
There's apparently an FBI investigation ongoing that the mother took the 2 younger children on a cruise, and that the older child, who was approximately 16 years of age, is a suspect in the death of the stepchild, an 18-year-old daughter that was in the same room.
Whenever I was on FaceTime with her, and when I was on FaceTime with her, and she was laying down, and the brother tried to go on top of her, and
you saw that?
Yeah. And then,
how did she react to that?
I was like, what the hell are you doing in her room, you know? Then he got scared and like ran away. And I heard his footsteps like running through the house, you know, because he got caught.
Mom, immediately after the incident, he was hospitalized, and then when released from the hospital, Mom and Dad participated too. They signed a stipulation basically allowing him to live with Mom's relative, and they're getting counseling and so forth for him.
It was suspicious because I knew that the brother did it, and yeah.
How do you know that?
Because of the past things that happened with him, like I was saying.
Now, according to family members, a cabin steward found Anna Kepner's body under the bed of her cabin room in that cruise ship. Investigators say the teen died from asphyxiation. And now the teen's father, the one who is a person of interest suspect who hasn't been charged, Thomas Hudson is the father, and he has filed a petition claiming he's concerned that a younger child that he shares with his ex-wife, Chantel, was in imminent danger due to those events on the cruise ship. So let's get you into the courtroom for the start of today's hearing. And a quick note on this, we do have the name of the teen suspect's name muted, so you won't hear that. You'll hear the audio drop. Let's go in.
I wanted to address a couple of things. I reviewed the emergency motion for temporary relief, Mr. Smith, and it does appear as though a lot of the allegations alleged within that motion are really in the nature of contempt. I know that there is a contempt proceeding, a contempt hearing being held on December the 17th, I believe, before Magistrate Valentine. The court's purpose in the hearing today is only to address the issues as it relates to an emergency. So as I'm looking at the motion, the paragraph specifically that the court will address would be related to paragraph 7. The 16-year-old child is now a suspect in the death of the stepchild during the cruise. While released from custody, the 16-year-old child is residing with a third party. Paragraph 17, the 16-year-old's future has been put in jeopardy because of the choices made by the respondent. And paragraph 19, and most importantly, the youngest child is at immediate risk of abuse, abandonment, or neglect in the care of the respondent. So those are the issues that the court is going to address here this morning, is whether or not, in fact, the court needs to take some sort of emergency action based on those allegations contained within the motion. As it relates to the other provisions in there with regard to alienation and violating court orders, et cetera, I'm going to allow those that was properly referred to the general magistrate, and that hearing has been set for December the 17th.
Yeah, and I understand the court's ruling. Obviously, we think part of the alienation of the children is part and parcel of the immediate risk to the children because the father is limited in his contact with the children.
Well, and it's okay to address those issues because that goes to the risk to the children. But if the goal is for the court to hold mom in contempt because she's not allowing the children to speak to dad or something along those lines, that's really more of a contempt issue. So I'm really specifically interested in the risk of abuse, abandonment, and neglect of the youngest child. And also to hear the status of the middle child. I understand that there was a stipulation and that the child was residing with a relative, a third party. That, of course, will be important to the court to determine whether or not the youngest child will have any contact with that child and whether that could create an imminent risk to the child.
Yes, Your Honor.
Any questions then with regard to the court's ruling on that?
No, Your Honor.
Ms. Athanasson, any questions from you?
No, Your Honor.
All right. Whenever you're ready, Mr. Smith, you may begin with opening.
Your Honor, in this case, obviously, it's our position that the youngest child is at risk for a number of reasons. As the court is aware through the pleadings, there's a young lady who's passed away. That matter is still under investigation. That was not my client's child, but the stepchild of the mother in this case, and the remaining 16-year-old is now a suspect in that case. In this case, the mother took the children, both Brooke, on a cruise against my client's wishes, while preventing him from having regular contact with those children. We believe that the arrangements that were made by the mother as far as the sleeping arrangements were insufficient, that the 18-year-old, the 16-year-old, and another 14-year-old were all placed in the same stateroom. There's indications that they may have, because they were in international waters, may have been engaging in activities that they normally couldn't engage in while they were in the United States properly being supervised. In addition, we will present evidence that through the older child who's now 18, so he's an adult, but he is the son of the parties, as to violence, alcohol use in the past, and he's been living with his father for approximately almost 2 years now, since these parties had their separation, where, as the court is aware, there was an original divorce case, there was parenting time, both parties were in Hernando County. Then the mother relocated by agreement between the parties over to Titusville. Since she relocated to Titusville, that's when the problems have occurred, where the father has been very limited in his access to the children. I'd reserve with regard to any other comments until closing.
Okay, we're just starting out with this custody hearing. We'll get you back in for more after this quick break. Again, this is a hearing that is surrounding this cruise ship death of 18-year-old Anna Kepner. And it's not in Florida where all of that happened, but we will bring you more of the details coming up next.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8/7 Central, only on Court TV.
The Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Welcome back to Court TV Live. We are bringing you a custody hearing in family court in Florida, where the people involved are also related to the Carnival cruise ship death mystery case involving 18-year-old Anna Kepner, who was found dead. As the FBI investigates this death, Thomas Hudson, the father of the teen who the family suspects in that death, has filed an emergency motion. Now, Thomas claims that the youngest child that he shares with Chantel Kepner, who is Anna's stepmom, was in imminent danger due to the events on the cruise ship. So let's go back in and listen to more of the opening remarks that are happening between these two attorneys who represent this mother and father.
Let me ask you this question, Mr. Smith. If the oldest child has been residing with the respondent for 2 years, and this we're dealing, I understand, I saw that there's a supplemental petition for modification that's also pending, so that would be an ultimate issue for trial. How would this, is it your intention to have the oldest child testify?
Yes, Your Honor.
And what if has the oldest child had any contact with the two other children or the respondent since he's been living with the petitioner for the last 2 years?
Well, one of the main things is the circumstances where he wound up living with my client. There was a physical altercation.
That would have been 2 years ago, correct?
A year and a half, yes, Your Honor. And he was also allowed to drink alcohol, which again, I think goes to the relevancy of whether these children whether the mother in this case encouraged the underage alcohol, especially on the cruise ship. And the violence that, again, the allegations are this 18-year-old has passed away in a violent manner. The 18-year-old will testify as that there was violence between himself, his mother, and the stepfather. And he has had recent contact with Brooke, and I think that goes to the whether there's any risk to Brooke returning to the father. The child was allowed finally to come over for a Thanksgiving visit.
The child being Brooke?
Brooke.
Okay.
She was restricted from contact with the one that there are allegations against, but did have contact with Andrew, her adult brother, and exhibited no fear, no reservations. Both my client as well as the 18-year-old can testify about that.
Well, remember though, this isn't we're here on an emergency motion. So this isn't an issue as to where it is in the best interest of the minor children to reside. That is ultimately an issue for trial in the modification action. The only issue that we're here to address today is whether or not Brooke is in imminent danger remaining in the petitioner's care as a result of recent incidents. So that's really primarily the court's concern today.
Well, and Your Honor, I understand that position, and certainly whether or not the child's to be removed from the mother is whether or not there's an imminent risk to the child. I think the court also has to look at where the child would be placed and the circumstances there as to whether there's any harm to relocating the child. I think you have to, in terms of emergency relief and an injunction, essentially, you have to look at.
I think you're looking at two different things. This isn't an injunctive relief. We're not here seeking, you're not here seeking injunctive relief. That would have been in the injunction court, correct?
Well, we're seeking to have the child removed from the mother and placed with the father. So I think that the court needs to look at whether or not there would be any harm to that. Obviously, our position is there wouldn't be, that she'd be able to transition to the father fine.
Okay, I'm not sure I agree with your argument, Mr. Smith, but I understand what your argument is. Okay. Ms. Anderson, opening?
Yes, Your Honor. May it please the court. We believe, and I think we filed that in our response, that there's no emergency that exists. There was an incident on the cruise ship. The Federal Bureau of Investigations is investigating that. There have been no arrests made yet, but since my clients were advised that he was a suspect in that, after he was released from the hospital upon the return to the United States, he was placed with a relative of the mother's. And not only did that happen, but mom contacted dad, and dad signed an agreement to say that this child would be placed with a third party, thereby removing any risk of any danger to any of the other children in the home. So that has been resolved, and there's been nothing mentioned of that. Nobody's saying, I don't hear the other side saying that they participated in that in any way, whereas the father was advised and did participate. The minor child, Brooke, you're going to hear testimony that she's fine, that there is no risk to her. There were abuse reports made. We have a person here from the Department of Children and Families that can attest that there's no concerns about the child remaining in the care of Chantel and Chris Kepner.
All right, thank you.
All right, those are the opening remarks from either side. Let's bring in former prosecutor and constitutional attorney Chris Ann Hall, who was watching along with us. A lot to unpack here, Chris Ann. I mean, this has been a story that's captured so much attention. We don't usually show custody hearings in our cases, but in this case, the FBI is investigating. There have not been any arrests yet, but in a court of law, they are having to decide whether or not there's this issue of the minor children still being around the young man, this teen, who is a named person of interest, according to what the family told their attorneys.
Yeah, this is going to be a legally fascinating case because you have the custody issues that are going to take place in Florida based on Florida law, but then you also have the death case in which we're dealing with maritime law and the U.S. Department of Justice, the FBI. So it's really going to be a fascinating weaving together of two different kinds of laws. What's interesting here in the state of Florida, the inclination in law is to keep a child where they are. So the burden of proof has to rest on the side that wants the child's custody to be removed. And there will always be a tendency, even a judicial tendency, to keep a child in a place where they are, and the burden of proof has to establish probable cause that no other remedy can ensure the safety of the child other than removal. So there really is a predisposed understanding that a child needs to stay in the custody pattern that they're already in, unless there's no other way to solve the problem.
All right, Chris Ann, I'm so glad we have your insight, especially being a Florida barred lawyer. Let's get to our break. When we come back, we're going to hear more from the stepmom side of things in the emergency custody hearing when we come back. Plus, don't forget, we have a verdict watch that is going on in Georgia. This is the case versus TrinityPoague. She was accused in the toddler death of her boyfriend's child. The jury has been out 52 minutes now. They heard riveting closings earlier today. If they have a question or they come back with a verdict, we will take you there into that Georgia courtroom. Stay with us. You're watching Court TV, your front row seat to justice.
for you.
Welcome back to Court TV Live. I'm Julia Janae. We're taking you back into that Florida courtroom. It's family court, a child custody hearing between the victim, Anna Kepner's stepmom, and her ex-husband. Of course, Anna Kepner was the 18-year-old who was found dead on a cruise ship. Her stepbrother is someone that has been called a suspect by authorities, according to her family. Now, let's get you back into the courtroom now. The stepmom, Chantel Hudson Kepner, is on the stand. She is speaking about the day that Anna Kepner died. Let's keep in mind that we are muting the name of the alleged minor suspect's name, so when you hear the audio go out, that's the reason. Let's watch.
Please state your name, ma'am.
Chantel Kepner.
And do you know Thomas Hudson?
Yes.
And how do you know Mr. Hudson?
We were formerly married.
And how long were you married?
About 12 years.
And do you have any children between the two of you?
We have 3 children.
What are their names and ages?
Andrew's 18, 16, and Brooke is 9.
And there recently was did you recently go on a cruise?
Yes.
Okay. And did any of the children go with you on the cruise?
Brooke and...
Did you reach out to Mr. Hudson to request that he agree to passports for the children?
I reached out to him to inform him of my itinerary to take the children on a cruise and did ask for the passports, but they weren't needed in this cruise.
And Mr. Hudson actually refused to cooperate with obtaining passports, correct?
To sign for the passports, yes.
You said passports weren't necessary, so they weren't obtained?
Correct.
As far as the minor children, what were the sleeping arrangements on this cruise?
Brooke was in my room with my husband and his 9-year-old daughter, and then shared a room with his stepsister and stepbrother. The room was directly across from ours.
What was the stepsister's name?
Anna Kepner.
And what was the stepbrother's name?
Connor Kepner.
And how old is Connor?
14.
And how old was Anna?
18.
Now, who made the decision to have these 3 teenagers in one room in the cruise?
We had talked it over with our travel agent, and that was what was suggested.
Did you have to sign any special permission for the children to reside together? So was it a mutual decision between yourself and your husband?
Correct.
And at some point, did you discover that one of the children had passed away?
Yes.
And when was that you discovered that?
Friday morning.
When was the last time that you had seen the child before that Friday morning?
Thursday night.
You know approximately what time?
Right around 6:30.
And your child, did you see him that Thursday night as well?
Yes.
What time did you see him at?
Closer to 7. Just a little bit before 7.
And what was he doing at that time?
He was headed back to his room.
Do you know whether or not Connor was present in the room as well?
They all were headed back to their room, as far as I know.
So, where was their room in relation to your room?
Right across the hall. You walked out my door, their door was right in front of it.
Did you return to your room that evening?
Yes.
What time did you return to your room?
7 o'clock.
7 p.m.?
Yeah, right. It was actually closer to 7:30.
Did you stay in the room for the rest of the night?
Yes.
With the teenagers across the hall, did you ever go in and check on them?
No, I had went to sleep.
Do you know if Christopher went across the hall to check on them?
Not that I know of.
Do you know if Connor ever left the room that night on that Thursday night?
I never seen him leave the room.
As far as goes, have you made arrangements for to reside with a relative?
Correct.
And why did you do that?
It was something that his father and I mutually decided.
Did you suggest it to him, or did he suggest it to you? Who brought it up first?
It was something that we had talked about because neither one of us could bring it back to our home.
Why couldn't you bring back to your home?
I'm looking out for the safety of the other children in the home.
Now, when you talk about the home, you have a home with Christopher, your husband?
Yes.
Okay. And does Christopher have other children that come to that home?
He has 2 other kids.
And one of them being Connor?
Correct.
And the younger child that slept in the room with you as well?
Yes.
Is Connor still allowed to come to the home?
Yes.
How many bedrooms is the home that you're in?
We have a 3-bedroom house with an addition room downstairs.
So what are the sleeping arrangements when all the kids were there prior to this cruise?
The 2 youngest girls shared a room, the 2 boys shared a room, and Anna had her own room.
As far as the evening, that Thursday evening on the cruise, had you been drinking at all?
No.
Had you drank at all during the cruise?
I had 2 pina coladas and a blue Hawaiian earlier in the week, but it wasn't on the same day. It was like 1 a day.
Do you know if the children, based on being in international waters, could have drink alcohol?
No.
You don't know?
No, they didn't. They're not old enough.
What about Anna?
I don't know.
Weren't you aware that the children were gambling at some point?
Well, Anna's 18, so I know she was in there at one point in time, but the other kids were not.
You're sure that the other kids were not gambling?
I'm sure the other kids were not gambling.
As far as does he have any diagnoses?
He has ADHD.
And how long has he been diagnosed with ADHD?
About 3 or 4 years.
Those after your separation from Mr. Hudson, correct?
About that timeline, yes.
And does he receive medication for his ADHD?
He does.
And what medication was he on for his ADHD?
Methylphenidate.
Would you pronounce that for me and spell it for him if you know?
Methylphenidate, I don't know the spelling.
Okay.
The name brand's Concerta. That helps.
Okay, thank you.
And how often would you take that medication?
Every morning.
Step aside for a break. Keep in mind, we are in a family court setting. This is not a criminal court. But I wonder if any of the information that's coming out in this court setting could be used if there is a criminal trial. We'll talk about it with our analysts on the other side of this break. Stay with us. You're watching Court TV.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
It's a massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Now back to Florida for a child custody hearing involving the family of Anna Kepner. She was the teen who was found dead on a cruise ship last month. And Chantel Kepner, her stepmother, who was married to Anna's biological father, Christopher, is in a dispute with her ex-husband over the custody of their minor children. And that includes Anna's 16-year-old stepbrother, who's being investigated in connection to her death, according to the family. Let's pick things up where we left off. The judge is hearing about possible living arrangements for the children while they were on this cruise, and also they're going to get to whether or not that teen stepbrother was medicated during the time of the cruise. We want to remind you we have been muting the audio when they mention that minor stepbrother's name because he has not been charged.
Did he take the medication on the cruise with him?
Yes. He also takes a nighttime pill as well.
The same medication?
No, it's clonidine.
What is that for?
Insomnia.
Did you hold on to the medications?
Yes.
Did you make sure he took his medications every day?
He took his morning pill every day, and he missed 2 doses of his clonidine at night.
You held on to the clonidine as well?
Mm-hmm.
That's yes?
Yes, sorry.
And what do you mean he missed the doses? What happened there?
He went to bed before he got it. He was already asleep.
Including that Thursday night?
No, Thursday night he didn't get it. I had fell asleep before he did.
So just to make sure I understand, ma'am, while on the cruise, he missed taking that nighttime medication twice. One of the nights was because he fell asleep prior to taking the medication, and the other night was the night before.
Correct. I fell asleep before he did.
You fell asleep, so he did not get the medication the night.
Yeah, he didn't come
before the
for it.
incident.
Yes, ma'am.
All right, thank you.
And was Brooke attending school prior to the cruise?
Yes.
And after the cruise, did she have to be removed from school?
They placed her on homeschool. They just unenrolled her this past Monday.
And why is that?
That was their choice to unenroll her.
Say their choice. Who are you talking about?
The school's choice. It had nothing to do with her behavior or anything. It had to do with the media.
She's currently on a homeschool status indefinitely?
No, she's being enrolled into another school.
Did you discuss that with Mr. Hudson?
I let him know that he had asked me to let him know when she was enrolled, and I told him I would. But I had just found out this week that she was unenrolled from the school.
As far as, is he going to be allowed to come back to your home at any point?
At this time, no. Not with the FBI investigation.
Whether or not your husband will allow him to return to the home even if the investigation concluded?
As of right now, he's not coming back to the home.
Ms. Kepner, who all went on the cruise with you?
Myself, my husband, Anna, Connor, the 2 youngest girls, and then my mother-in-law and father-in-law.
What are their names?
Jeff and Barbara Kepner.
And where was their room in relationship to where your room and the children's room was?
2 floors above us.
Did they also help in the supervision of the children?
Yes, ma'am.
Anna, who we know passed away, she was 18, correct?
Correct.
And she was an adult?
Correct.
And Was she given the option of staying in another room?
All three of the kids were.
Okay. And would that room have been with Grandma and Grandpa?
Correct.
And they didn't want to do that?
No, they wanted to stay together.
Did they all get along?
Yeah, the three of them are like the three amigos. They're best friends.
Okay. And with regard to Connor, I know you were questioned about him. He's not a suspect, or you haven't been advised by anyone?
Correct, he's not a suspect.
As far as you know, is the only suspect in the death of Anna, your son?
Correct.
And with regard to the schooling, this was the movement of the children from one school to another wasn't because you just decided to randomly remove the children, correct?
Correct. The school decided to unenroll all of the children at the school.
Okay. When you say all of the children, who?
We had 4 total, including Anna, go to that school. They unenrolled all the other 3 kids.
Okay. All right. Because of and you were told because of the media coverage?
Yes.
And did they give you the recommendations of the school that you have enrolled them in?
Yes.
And that this new school is aware of the situation?
Correct.
And there's been no problems with Anna at the school, with Brooke at the school since this incident, correct?
Correct.
She was a good student?
Yep, straight A's.
I don't believe I have any further questions at this time.
Any redirect?
Just briefly. As far as Brooke, you mentioned her being a good student. Is she also diagnosed ADHD?
No.
Is she on any medication?
Yes, she takes some migraine medicine daily.
And are you the one that administers that medication?
Yes.
How long has she been on that medication?
She's been on that medication for 2 years now.
No further questions, Joe.
Thank you. Anything else?
No, Your Honor.
All right, you may stand down.
Thank you.
That wraps up the testimony of the stepmother of the victim in that Carnival Cruise death. Chris-Ann Hall still with us, former prosecutor and constitutional law attorney. Chris-Ann Hall, I want to ask you about the commentary that we've heard from the mother in this. This is a child custody case. It is not a criminal trial. How much of it, though, do you think could be used if we see a criminal trial?
Well, statements made in the Florida custody hearing can absolutely be used by federal prosecutors. The confidentiality of a family court hearing does not extend to federal homicide criminal investigations. Even though the family court case is civil, anything said under oath becomes fair game in a federal homicide case unless the witnesses invoke the Fifth Amendment. Confidentiality protects the public from seeing the testimony, but it doesn't shield that from the FBI. To use a family court testimony, the federal prosecutors, they simply have to subpoena the sealed records and ask the federal judge to unseal it. And like I said before, the federal the Florida confidentiality rules do not block federal use of these things.
Okay. Anything you've heard from the stepmother on the stand that makes you think that there's a possibility we won't see criminal charges, or maybe the most harsh criminal charges, against the suspect?
No, it's going to be hard to tell. It's going to, like I said, it's going to be very interesting. He is only 16 years old, so technically he would be tried under juvenile justice laws. It's very rare that they elevate these things to adult cases, but that'll be left to see.
Chris-Ann Hall, thanks so much for your analysis. We've got to get to a break. When we come back, we've got more of this emergency custody hearing, and the brother, eldest brother of that suspect is going to be testifying next.
Cellular. Plus, for a limited time, new customers get their second month free when they sign up today.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you on this Friday, where we are bringing you a family custody hearing in Florida. Why? Well, because the people involved are also related to the Carnival cruise ship death mystery case. This involving 18-year-old victim Anna Kepner. And as the FBI investigates Kepner's death, Thomas Hudson is the father of her stepbrother, who is allegedly named a suspect in her death, and that father has filed an emergency motion. Thomas claims that the youngest child he shares with Chantel, who is Anna's stepmom, was in imminent danger due to the events on the cruise ship. We'll hear from him later this hour, but for now, Thomas and Chantel's eldest son is on the stand. And a reminder, the name of the alleged teen suspect in this case has been muted throughout, so if you hear quiet, that's why. Let's go back in.
Please state your name, sir.
Andrew Hudson.
And how old are you, sir?
18.
What's your birthday?
10/4/07.
You just turned 18 October 4th of this year?
Yes, sir.
And who do you reside with?
My dad.
And how long have you resided with your dad?
2 years.
And when you've been residing with your dad, have you been able to maintain contact with your brother?
No, not really.
What do you mean, not really?
Very, very little contact.
And why is that?
I haven't been allowed to see him. Yeah.
Who has he been living with up until recently?
Up to my knowledge, my mom.
How about your sister, Brooke? You've been able to have contact with her since you've been living with your father?
I've seen her a few times, but it's kind of the same thing as my brother.
You mean you haven't been allowed to see her?
I've seen her recently once, but other than that, it was a while ago.
The recent time that you saw her, when was that?
I don't remember the exact date, but it was a weekend or two ago.
Did it coincide with the holiday?
Yeah, Thanksgiving. Yeah, sorry.
Was it Thanksgiving Day or just another day?
It was just Thanksgiving Day.
And how much time did you get to spend with Brooke?
It was about the full day.
Was your father there as well?
Yeah.
And did Brooke appear to be scared of your father in any way?
No, she was fine. She was happy-go-lucky, playing around.
Did you interact with Brooke?
Yeah.
How did things go between you and Brooke?
We had a great time. I was playing around with her. She was having a good time, up to my knowledge.
Before you started staying with your father full-time, did you and Brooke have a decent relationship?
Yeah, I mean, there was obviously the siblings, that kind of stuff, but other than that, me and her on good terms.
Are you still attending school?
Yes, sir.
You intend to graduate high school?
Yes, sir.
Is there any reason why Brooke couldn't live with your father?
No, not that I know of.
You doing well in school?
Yes, sir.
Why did you come to live with your father?
I believed I was better off over here with my dad.
Why did you believe you were better off?
Because I was going to finish out school and do trade school.
When your mother relocated, what was your understanding of what was going to happen with you?
I was going to finish out school over here and then possibly go to school to be a crane operator over there.
Had you talked to your mother about that?
We talked about it a few times, yes.
And is that what happened?
No, that's not what happened.
Okay.
Last day
Was there some sort of problem that occurred?
Other than what happened before when they came and took me.
So your understanding was that you were going to finish out school and then possibly relocate?
Mr. Smith, if I could get a time frame.
Yes, ma'am. Do you remember when this was?
I don't remember the exact date, no. But it was around prom, or it was right after prom of last year, not last year, the year before last.
So not during this school year?
No.
The previous school year?
It was, I think, 2 school years ago.
And
So we're talking about 2023,
I believe so.
and prom occurs generally in the spring or in the fall?
To be honest, I don't remember.
You don't recall?
do you remember where you are as far as how far along in school that year?
I don't, honestly.
So let me just stop you a second. So you're questioning about incidents that occurred back in 2023. How would that be relevant to whether Brooke is in imminent risk of harm today, as we sit here in December of 2025?
Well, you gotta, first off, I know he doesn't remember the date, but it would have been 24, based on the relocation of the parties.
But but let me ask you this, would it have occurred prior to the party's stipulation that permitted Mrs. Hudson to move to and relocate to Brevard County?
No, it was after, Your Honor.
So it occurred after the stipulation?
Yes.
Okay. All right, I'll give you a little bit of leeway then.
Was there some sort of altercation that happened between yourself and your mother?
Yes, when they came in and took me from, they came in and took me from school and took me to Titusville.
How did you find out they were taking you to Titusville?
After I got in the car and they had took my phone already.
What do you mean they took your phone away?
I had gotten in the car, and as soon as I got in the car, she asked me for my phone. She took it and powered it off.
Is that normal for them to take away your phone?
No, sir.
Who else was in the car?
It was my mom and my stepdad at the time.
Would that have been Chris?
Yep.
And did you let them know that you didn't want to go to Titusville?
Yes.
And how old were you at that time?
I was 16, I believe.
And how did you let them know that you didn't want to go?
I told them I didn't want to go.
And they still held on to your phone?
Yeah.
Did you try and leave the vehicle?
I did, yes. When we stopped, I tried leaving, but as soon as I would try to get out, they would speed off.
Did anybody physically touch you?
Yes, I was put in a chokehold and held up against the seat, the front seat.
Who did that?
Both my mom and Chris.
Did that happen on several occasions during the drive or just one time?
They held me against the seat until I couldn't fight back anymore.
So how long did that last for then? If you remember.
I want to say like 20 minutes, 2.5 hours maybe.
And do you know how long your mother had been dating Christopher prior to that?
If I remember correctly, 5 months. I don't remember exactly how long.
Had you been to Titusville over those 5 months when she had been dating him?
I've been over there a couple times, yeah. It was sometimes every other weekend.
And during the 5 months that your mother was dating Christopher, did she allow you to drink alcohol?
Yeah.
What were the circumstances that happened?
We were just drinking. She would be on the phone with Chris sometimes, FaceTiming, and she would allow me to drink.
What type of alcohol do you recall?
I don't remember exactly what kind of alcohol it was.
Was it cans or?
It was out of a bottle.
Was it poured into a cup?
Yes, sir.
Were any of your other siblings there that you recall?
My brother might have been there, but I honestly don't remember.
So based on Chris being on you said FaceTime, so he was aware of what was going on? He could see what you were doing?
I believe so.
Did you see what he was doing on FaceTime?
No, sir.
You said you've been living about 2 years with your father, correct?
Yes, ma'am.
All right. And that was after your mom relocated to Titusville?
Yes, ma'am.
Okay. And this incident that you were speaking about in the car, that was because you were trying to get out of the car, correct?
Yes, ma'am.
They were trying to restrain you from getting out of the car, out of a moving vehicle, correct?
The vehicle was not moving.
Okay. But they were trying to keep you from moving or jumping out of the vehicle, correct?
Yeah.
And you wanted to stay because you wanted to be with your girlfriend, correct?
No, ma'am.
Your father at that time, wasn't he living in a camper and not in a regular house?
Yes, ma'am.
Okay. And so you were staying with your grandmother then, correct?
Yes, ma'am.
Okay, and not necessarily with your father?
Well, I would be over there in the camper every now and then, but yes.
Primarily with your grandmother?
Mostly, yeah.
Okay. And did you also stay on certain occasions with your girlfriend?
No, not at all.
But mostly with grandma?
Yep.
So I'm confused. Were you living with your mom primarily during this time, or were you living with your grandmother primarily during this time?
After what?
Prior to the incident in the vehicle.
Prior to that, I was with my dad before. After she relocated, I was living with.
Before she relocated, who were you living with?
Before I was living with her, and then I would see my dad every other weekend.
Okay. And when were you living with your grandmother?
I was, it was like on and off between my grandmother and my dad.
After your mother relocated to Titusville?
Yes, ma'am.
Okay.
Thank you. And you were aware that your parents signed documents that she was going to be moving with all of you to Titusville, correct?
Yes.
All right. I don't have any further questions. Thank you.
Thank you. Any redirect?
Just when you said living in this trailer and living at your grandmother's house, was this on the same property or different properties?
It was two different properties.
Okay. Has your father subsequently obtained housing?
Oh, yes.
Okay. You have your own room?
Yes, I have my own room.
No further questions.
All right. Anything else?
No.
All right. Thank you, sir. You may step down.
All right, remember, this is a custody matter, an emergency family custody hearing in Florida. We're going to take a break. When we come back, we're going to bring you more of the testimony. Stay tuned.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8/7 Central, only on Court TV.
Back now to Florida in the child custody hearing between Anna Kepner's stepmom and her ex-husband. Kepner was the 18-year-old found dead on a cruise ship. Her stepbrother has been named a suspect, according to the family. Now, his father, Thomas Hudson, has filed an emergency motion regarding his youngest child. Thomas is now on the stand, and keep in mind we are muting audio of the alleged teen suspect's name. Let's go back into court together.
State your name, sir.
Thomas Hudson.
And Mr. Hudson, do you have any children?
Yes.
And what are their names and ages?
Andrew, 18, 16, and Brooke, she's going to be 9 this month.
She turns 9 in a couple days?
Yeah, on the 9th.
Did you enter into an agreement with your ex-wife to allow her to relocate to Titusville?
Yes.
And the both of you did that without attorneys? It was just an agreement that the two of you came to?
Yes.
And what was your understanding of what was going to happen regarding Andrew?
He was to finish out school with me, and then he would go over there.
And did that occur?
No.
What happened?
I don't remember the exact date. It was in April, I believe, of 24 that the school had contacted me because they had felt something was wrong with her coming and picking him up and the way she was acting. And so
So how did you react to that?
I was alarmed. So I tried calling Andrew and his phone was off. I tried calling her, no response, and Brooke and his phones were both off also.
Did you travel over to Titusville?
Yes.
Did you subsequently pick up Andrew?
Yes.
And has Andrew been with you since that time?
Yes.
Prior to Andrew coming to live with you in approximately April 2024, what sort of parenting time did you have with the two younger children?
Prior to her moving over there?
Yes.
It was Tuesdays and Thursdays and every other weekend, plus or minus the holidays.
And did that continue once she relocated?
No. It was supposed to be every other weekend, and then the holidays worked out.
And were you allowed to see Brooke?
No.
Did you make attempts to try and?
Yes.
Did the agreement have an exchange location where you were supposed to exchange Brooke?
You're supposed to exchange at the racetrack in Winter Garden, I believe.
Did you recently get an opportunity to visit with Brooke?
Yes, I was able to go and pick her up in Titusville for Thanksgiving.
And how did the Thanksgiving visit go?
Went good.
Did your ex-wife inform you that she was going on a cruise and taking the children?
She did.
And what was your position regarding that?
I wasn't okay with it. I let her know I wasn't okay with it.
And why was it that you weren't okay with it?
Because at that time, I was getting nowhere with seeing my kids. I had barely any communication at all.
So you weren't even able to hardly talk to them?
No.
Have there been occasions where you've been able to talk to them?
Occasions, she would have them talk just to say that they didn't want to talk to me.
Was that by phone?
Yes.
Do you know whether or not she was present there with the phone?
I mean, I heard them there. Occasionally they would talk because I would be on speaker.
You heard your ex-wife there?
Her and Chris.
Were there ever attempts for an exchange?
Yes.
And what occurred during those attempts?
They wouldn't show. They would say that she would say that they didn't want to come with me and that she wanted to proceed with therapy in advance before we did anything.
Did you have any problem participating in therapy if that was arranged?
No.
Did you ever get invited to any therapy?
She might have invited me. I don't remember exactly, but I did speak with a therapist.
Did that therapist remain the therapist for the children?
No, I don't remember when they removed them from that, but to my knowledge, they didn't get another therapist after, I believe her name was Amber.
Did you recently agree for to reside with a third party?
Yes, that way I can get them away from the whole situation over there.
When you say the situation over there between Chantel and Chris?
Yeah, the whole situation, I didn't really want him going into a facility or to Chris's friend that has a tow truck company. That was a suggestion.
Those were the other suggestions?
Yes.
And as far as is located closer to you now?
Yes.
And are there restrictions on your contact with?
I'm not supposed to go over there. I do talk to him. I'm not supposed to go over there. I'm not supposed to really talk to him.
Why? What do you mean? Why are you not supposed to?
I don't know. I tried to get, when I had Brooke for Thanksgiving, I tried to get all three of the siblings to see each other because they've all told me they wanted to see each other. So I had messaged Chantel and she wasn't okay with it.
And so you,
hold on just a second. Let me understand this, sir. We're here for an emergency motion because you believe Mom has made some decisions that are detrimental to Brooke.
Yes.
As a result of some things that happened on the ship, but you were going to take Brooke to see or to get to be with Brooke. Is that what I'm hearing you say?
She asked to see her brother.
So because an 8-year-old asked to see her brother, you were going to accommodate her to do that?
Supervised, yes.
Go ahead.
And because the mother said no, you didn't do that, correct?
No, correct.
And it's her family that has in their care right now, correct?
Correct.
Are you having more contact with her now than you've been allowed to have in the past?
Yes.
And as far as in the past year, let's say, you've been having a lot more contact with her now?
Yes.
Did you have some concerns for care while he was with his mother?
Yeah, honestly, I didn't know what all was going on.
Is that part of the problem? You're not aware of what's going on with either Brooke or?
Correct.
Were you aware that he was prescribed some medication?
I knew he was on medication. I didn't know exactly what kinds, what names.
Was that discussed with you prior to going on the medications?
No, I was told after he got the prescriptions.
Did you express your concerns to the mother?
Yeah, I mean, I know everybody needs to be on certain things for certain situations, but I'm not okay with a lot of the side effects on some of the medications.
As far as you talked about the exchanges, have you ever seen the stepfather, Chris, interfere with the exchanges?
Yes.
And how so?
Just before Thanksgiving, we met at a fire station, and he and his family got out of the car. Chantel never got out. Brooke refused, of course, to get out, and I think after he said the third time, she said she didn't want to go. He stepped between me and the door, closed the door, said to get away from his vehicle, and that they were leaving.
So you weren't given the opportunity to try and take Brooke out of the vehicle?
No, I was told not to reach my hands inside the vehicle or anything.
Had either Chris or his family attended other attempts to?
Chris has, yes.
Have there been any of these attempts to have parenting time where Chris hasn't been involved?
Not that I can recall, no.
Back on March 12th of last year, of 2024, you signed an amended parenting plan at that time regarding your 3 children, correct?
Yes.
And that document was filed with the court. And an order was entered to approve it, correct?
Yes.
Okay. And did anybody hold a gun to your head to sign that agreement?
No, I thought we came to an agreement.
Okay. And so you signed it freely and voluntarily?
Yes.
And that agreement was for all 3 children to be able to relocate to Titusville with Miss Kepner, correct?
Yes.
Okay. So when you testified earlier that it was your understanding that your oldest son was going to stay and finish out the school year, that's nowhere indicated in the paperwork, correct?
That was an agreement me and the mother had.
Okay, so you're saying it was a verbal agreement, but it wasn't in the amended parenting plan that you signed, correct?
No, ma'am, but that's what my oldest wanted at the time.
And you were aware that that language was not contained in the amended parenting plan that you signed, correct?
Yes, that's why we had the discussion.
Mm-hmm. And when you had this verbal agreement, there was no further written agreements made to solidify that, correct?
I could probably go through and see if there was any text or anything. That might take a while, but as far as I remember, it was a verbal agreement we had a talk with Andrew about.
My question was there wasn't anything signed by both of you saying that your son Andrew, who was 16 at the time, was going to remain in Hernando County, correct?
No, it was just an agreement.
Okay. You indicated that you saw your daughter for Thanksgiving, correct?
Yes.
And how did you effectuate that visit?
I don't understand. What do you mean?
So you sent a text message or an email to Miss Kepner saying you were coming to pick the child up for Thanksgiving and to meet at the designated meeting place, correct?
Yes.
Okay. And she appeared with the child, correct?
Correct.
Okay. The weekend prior to that, on the day of the funeral of the 18-year-old child, you had sent a message that you wanted to pick up Brooke the next day, correct?
Yes.
And that you expected them to be there, correct?
Correct.
And they showed up, correct?
Yep.
Your daughter didn't want to get out of the car, correct?
Correct.
Okay. And prior to that, wouldn't it be fair to say, sir, that there were no other times when you sent a text message saying that you were going to meet at the racetrack or any other location to come pick up your children for your time sharing, correct?
There is a lot of times stating that I was going to be there and I could show up.
Let me bring in trial attorney Bob Hilla. And Bob, this is a little bit different than most of the criminal trials that we cover. This is an emergency custody hearing, as you well know. And this is the father of a youngest child filing this to say, I don't want the youngest child around the alleged suspect in the murder of Anna, who is also a minor child. How is this playing out in your mind?
Well, I think in terms of the credibility, this witness is pretty credible, and it was kind of funny because I think there was going to be a follow-up cross. She was expecting, I think, the witness to deny certain things, and he didn't. So there was sort of a pause there. But I think, you know, ultimately, like with any case, they have to prove the merits, but what does this court have to decide? There was a parenting plan. This court now needs to weigh the evidence, the credibility of the testimony, and make a decision. Do we change that parenting plan, and why? And basically, though, here, the standard is what's best for the subject child. There is always a presumption that, in this case at least, since there was a custody plan approved by the court, that remain in effect. But now they want to change because now there's some sort of a change in circumstances that places the child at risk. At least that's what would be implied by these proceedings. So now this judge has to look into this case and the evidence before her and decide, what is it? Is there a change in circumstance that puts this child at risk? What is that? And is residing now with the father, you know, the answer to protecting the child and the best interest of the child, which is basically what the court's charge is in this circumstance.
Right. All right. Thank you. That gives so much context to our viewers of exactly what's happening in this hearing. You're going to stand by because we'll talk about how it relates, if it does, to any potential criminal charges next. But we need to take a break. We'll bring you more of this emergency family custody hearing in Florida. Plus, we are in verdict watch in Georgia versus Trinity Poague. You can see up on your screen the jury has been out for an hour and 56 minutes. Of course, when that verdict comes in, we'll bring it to you live here on Court TV. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. We are in Florida today for a hearing related to the cruise ship death of teen Anna Kepner. Chantel Kepner, who is married to Anna Kepner's biological father, Christopher Kepner, is in a dispute with her ex-husband over the custody of 2 of their 3 children, one of which is being investigated in connection to Anna's death. Let's go back inside the courtroom for this civil case. Chantel's stepmother is on the stand testifying about underage drinking occurring in Chantel's home.
Please state your name, ma'am.
Sonia Zisk.
Okay. And do you know Chantel Hudson?
Yes, I do.
How do you know that? How do you know Chantel?
I'm her stepmother.
And do you recall if Chantel relocated to Titusville?
Yes, I do.
Do you know where she was living prior to relocating?
Excuse me, Your Honor. Can we ask the witness to speak up? I can't.
Ma'am, if I could get you to speak into the microphone, ma'am, so that everyone's able to hear you. Thank you.
I'm sorry, what?
Do you know where she was living prior to her relocating to Titusville?
Yes, she was living with us.
And what city do you reside in?
Wikiwachi?
Were you residing in Wikiwachi at that time?
Yes.
When was this, ma'am?
We've been there for about 2 years now, so 23? Around summer of 23 is when we moved where we're at.
Summer of 23?
And did Miss Chantel reside with you there from the time that you moved there?
Yes.
Okay. And do you recall how long she lived with you until she relocated to Titusville?
She moved in there around, we did like June, and then I want to say by I want to say it was probably April of 24, right around there. I don't know exactly.
About April of 24 is when you recall that she relocated?
Yes, it was before the end of May, so it was before school got out.
Are you aware of, while she was living with you, were you aware at some point that she was allowing the minor children to drink alcohol?
I saw it one time.
What were the circumstances? What did you see?
I walked in the house. They were sitting at the island.
Who's they?
Chantel, Andrew, and were sitting around the island. And I do believe, I think it was Chris that was on FaceTime. And they had shot glasses in front of them. And I'm like, what are you doing? She said they just wanted to taste what it tasted like.
Who's they?
The boys.
She allowed all 3 boys to?
There was 2, Andrew and.
So she allowed there was 3 shot glasses, 1 for mom, 1 for Andrew, and 1.
Yes, ma'am.
What was your relationship with the children while they were residing with you?
Very good. Very good.
And just to clarify, as far as you indicated, your stepmother, Chantel, correct? You're married to her father?
Yes.
And her father resided in that home as well?
Yes, sir.
Since she moved over to Titusville with Chris, have you and your husband been allowed to have contact with the minor children?
No.
No further questions on this witness.
Chantel didn't live in the actual house with you, with the kids. She lived on another home or parcel on the same property, correct?
About 100 foot from mine. They're about 100 foot apart.
Okay. But she wasn't with you in your particular house, correct?
No.
And neither were the kids?
No.
Okay. You said that you saw the kids drink alcohol on this one occasion. It was just the one occasion?
Yeah.
Okay. And what was it that they were allegedly drinking?
I did not look at the bottle that was sitting there.
Well, how do you know it was alcohol?
Because I knew it was alcohol. I didn't look at the name of the bottle. There was a bottle sitting there. I didn't look to see what the name was. I went on about my business.
And did you say anything to Chantel that you didn't think that was a good idea or anything like that?
I questioned it, and she said they wanted to see what it tasted like, so she said she was going to let them while they were at home instead of out somewhere.
Okay. And you said that since that Chantel moved to or relocated to Titusville, you haven't seen the children. You haven't called her to request.
Oh, yes, I have.
Oh, you said you're saying
I have
that you
left
called
messages. I have texted her. We have reached out. There was a falling out about Chris, and she didn't want anything else to do with us because her dad told her that he couldn't come around.
Because your dad, meaning your husband,
Yes.
told her that Chris couldn't come around?
Yes.
Okay. And this falling out was because Chris allegedly cut some trees to clean up the yard at your request, correct?
That and some other things, but that's something you'd have to ask him his opinion.
Okay.
Or I'm not going to answer for him.
Okay. But it would be fair to say you haven't seen the children since she's relocated.
I haven't.
And you haven't sent them a Christmas card.
Oh, yeah. I called to get her address. I texted her to get her address, and she wouldn't give it to me.
Okay. And you haven't.
And I still have their gift cards that I had gotten them.
Okay. But you didn't give it to them.
I wasn't allowed to.
I see. Okay. Have you ever been to Titusville? Did you ever come over here?
No.
Okay.
Why am I going to drive 2.5 hours if I'm told I can't see them?
No, I have no further questions, ma'am.
Redirect.
In addition to being told you can't see them, you were denied even having their address, right?
Yeah.
And when you said there was a falling out and Chris was told he couldn't be around, was that you or was that your husband?
It was my husband.
And this property that we're talking about, was it your husband's property?
It was ours, yes.
Okay. And you had mentioned another home. Were both homes on your property?
Yes, sir. And the reason that I say she lived with us is because we actually were in both houses because the houses are very small. So we had to use, I have 5 people in my home, and we had 1 restroom, and I told her that was part of the deal, is that we had to use that house too. So
you both used both houses?
We used both houses.
Would you see the children on a daily basis?
Yes. Brooke would always come over and see me and play with Max, and she was always at my house.
No further question.
Anything else?
No, Your Honor.
All right. Thank you, ma'am.
All right, stay with us. We do have to squeeze in a break, but up next, we're going to hear the judge's decision in this family custody hearing up next.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8/7 Central, only on Court TV.
Welcome back. Now turning to Florida, staying in Florida for the child custody hearing involving the family of Anna Kepner, the teen who was found dead on a Carnival cruise ship just last month. Chantel Kepner, who is married to Anna Kepner's biological father, Christopher Kepner, is in a dispute with her ex-husband over the custody of 2 of their 3 children. That includes Anna's 16-year-old stepbrother, who is being investigated in connection to the death of Anna. Let's get you back inside the courtroom now. The judge is about to make her ruling.
Not that I'm trying to deny you, Ms. Athanasson, of any time to put on your case, but you know, the issue for this court today is whether or not the children in this case are in imminent danger. And I've heard lots of testimony with regard to what happened back in 2024, what happened on the West Coast, but other than the incident that happened on the cruise, I've heard nothing to indicate that Brooke is in imminent danger or harm at this time. How long is he expected to remain with the relative?
At this point, we're not sure. We're not sure what the FBI is going to do, whether he's going to be charged federally or whether they're going to turn it over to the state. My client is waiting to hear on that. They're also waiting on some testing results. They've done a bunch of psychological testing and psychiatric testing, so they're also waiting to hear about that. And so they don't know at this time how long the child is going to be at her relative's house.
Is there any expectation that he will be coming back to Titusville in the near future?
No.
Okay. All right. Then, based on the evidence that's been presented today, I don't find that there is an emergency and that Brooke is in any imminent risk of harm. I understand that there may be some issues with regard to contempt. I understand that there is a hearing pending on December the 17th before Magistrate Valentin as it relates to the motion for contempt, and I believe an amended motion for contempt has been filed as well. But for my purposes, the only thing that the court was here to hear this morning is the emergency motion for temporary relief, most specifically as to paragraph 17 or 19, when it says the youngest child is at immediate risk of abuse, abandonment, or neglect in the care of the respondent. The court has not heard anything to indicate that there is an imminent risk to Brooke. Now, certainly, if there was a situation where he was returned to the home and is in the home with Brooke, that may be another basis to for a motion to be brought at that time. But so long as no longer in the home, I don't see that there would be any risk to Brooke. So yes, sir, I hear you, Mr. Smith.
I actually didn't say anything yet.
Okay, I look like you're about to. So I am going to deny the emergency motion for temporary relief. I will prepare a written order, and I will have that order filed, I would anticipate, by Monday or Tuesday of next week. All right, that concludes the proceedings. Thank you all very much.
An interesting turn of events. Still with us, trial attorney Bob Hillis. So, Bob, we just learned from the judge the reason why she's denying she's not going to do anything on this emergency motion is because the person, the minor child that is allegedly being investigated in connection with the death of Anna, has been removed from the home and is no longer in the home with the youngest child that father's concerned about. So the court said there's nothing there for me to consider because they're already separated. Your thoughts?
Well, yeah, I think the court got it right here. It's a very difficult situation. The judge rightfully was concerned about the suspect, who, by the way, is currently the sole suspect in the death of the half-sibling. So, you know, the real issue here was, and the only issue for this judge was, is the child in risk of imminent harm being with the parent? And the evidence, frankly, was pretty thin in that regard. Certainly there was no threat or risk to upset or change the current custody arrangement by virtue of anything that the biological mother is accused of.
So the real question, Bob, is how does this play in if there are any criminal charges against the alleged sole person suspect being investigated? Can this hearing be used in that proceeding? Does this give some information that can be used in preparing for possible criminal charges?
Well, you know, the question is always, is it discovery? Because it's going to clue the state or the federal government in on what people might say if it's relevant. Or was there anything of evidentiary use that could be admissible in the trial? I didn't really hear anything that had to do with statements made, inculpatory or otherwise, by the suspect that might bear any relevancy in the criminal matter. You know, so I think, at least from what we heard in this segment, I didn't hear anything that really was going to be impactful in the criminal trial, if there is one.
Yeah, we'll see what happens if there is one. Bob Hiller, always appreciate you coming on. Thank you so much for being with me. Coming up next, the jury has a question in the TrinityPoague trial in Georgia. On your clock, 2 hours, 19 minutes. They've been deliberating. Stay with us. We're going to bring you that next and find out what the jury has to ask. Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we begin this hour in Georgia, where the jury deliberating the fate of defendant TrinityPoague now has a question.
Poague is the former pageant queen charged with murder and the beating death of her boyfriend's son, J.D. The 18-month-old was found unresponsive in Poague's college dorm room, and later, that baby, right there on your screen, died at the hospital.
All right, let's go right into court now and hear the jury's question.
Court's 1, I'll mark this court 2. On court 1, I had written, somebody had written that we were going to send them back a note asking them what they wanted as far as food goes. I scratched that out. I told them not to send any other note back. But this court 2 reads as follows. What are the following? Count 2, felony murder. Count 3, felony murder. Count 4, aggravated battery. Count 5, aggravated battery. And then it says EG is 1 for the head and is 1 for the liver. So that's the question. It's signed by the foreperson who apparently is Mr. Phillips. So I think the only response, I think my impression of what I should do is bring them back in and tell them they have to read the indictment. I can't answer their questions about this. And they have to read the indictment, and then they have to consider my instructions as a whole and make a determination as to each count separately and independently, considering my instructions.
Do they have the indictment?
Yeah. Of course they have the indictment.
I mean, okay.
Yeah, right now? Yeah. Yeah, I mean, I saw y'all put it on top of the things, so I'm not sure.
Wouldn't exhibit.
I mean, you know, I know off the top of my head, count 2 is felony murder based upon aggravated battery. Count 3 is felony murder based upon cruelty to a child, and then the aggravated batteries are, 1 is for the head injuries and 1 is for the liver injury, I think.
Yes.
But I don't think that's my place to tell them that. I think they have to read the indictment and then make a verdict considering all the evidence and everything that has been instructed to do.
Yes,
do you
sir.
agree with that, Mr. Lamb?
I think so. I mean, I don't think that that the court should interpret the indictment for them, if that's what you're saying.
Do you agree with that, Mr.
I think that you
I
may,
do, Your Honor. I do. All right.
I mean, I think you may.
Let's bring them back in.
Just tell them that they'll, reread the indictment, that information is set out in the indictment, because it is, but I don't think you should interpret it for them.
All right, so while they bring in the jury, I want to bring in our guest. Joining us here this hour is criminal defense attorney Forrest Miller. Forrest, you heard what was going on there. Essentially, they're trying to figure out these charges. There's 2 felony murder charges, 2 aggravated battery charges. There is that top charge of malice murder. Maybe they kind of skipped over that or decided that wasn't the case. We don't know for sure. What are your thoughts on what we just heard?
Well, thank you for having me again. I appreciate it. Well, first off, the jury, it's coming up to the hour. It's 4 o'clock right now there. So, they want to ask questions. They want to make sure that they're doing their duty. I think that the judge is correct. He shouldn't be interpreting the indictment for them. That's their business and their understanding. But this is typical, right? A jury is going to try to make a decision, but they want all the facts and they want to be told how to think a little bit. So it's good on the judge that he's pushing back a little bit and letting them do their own thing.
All right, let's do this. I understand the judge is back in court speaking with the jury. Let's go in to hear what he tells them.
Question from the, I presume it's the foreperson, is that right? And it reads as follows. What are the following? Count 2, felony murder. Count 3, felony murder. Count 4, aggravated battery. And count 5, aggravated battery. And then it says EG is 1 for the head and is 1 for the liver. And I'm going to respond to this by asking you to refer to the indictment. The indictment has the allegations contained in it. You have to review the indictment, then you consider the jury instructions that I gave you, and you have to make a determination. You determine the facts. I've given you the law as to each of those offenses that are charged. You know, like what is aggravated battery, what is felony murder, what is cruelty to a child, and what is malice murder. You have to determine on each, you know, with regard to each of those charges, considering the allegations in the indictment, whether the evidence supports that, given the burden of proof that I've instructed you on in some detail, and the facts as you find them to be. But I can't really answer your questions. I'm not going to try to interpret what the allegations of the indictment are for you. You do have the indictment with you, is that correct? Okay, all right. So I'm going to ask you to return to the jury room and resume your deliberations.
All right, I agree with what the judge did, Michael. He simply said to the jury, when you're asking was one of the charges for the head and one for the liver, you have to refer to the indictment that sets out those charges, as well as the jury instructions, which explain what the law is that the jury has to apply.
Yeah, and it's interesting because the way our system works, you would think the judge would explain some of this to the jury, but that's not how it works.
It's not, and it's funny because I wouldn't think that as a former judge, right? But to your point, if you're not familiar with our criminal justice system, I think you might think that. It's really, it's something I think we know doesn't happen that way.
Exactly.
And I want to bring in Forrest Miller because I will tell you both, I'm a little bit surprised at 2:20 they had this question, because I would have thought a jury would look at everything in front of them, decipher it, figure out what they could do. And I think an indictment in jury instruction should theoretically really make it clear as to what the charges are. But Forrest, tell me if I'm off base.
You're not off base, right? They should be able to kind of interpret the law. But when you're in the jury room, and I've never been in the jury room, but you know, there's got to be some debates going on back and forth. And when you're debating certain fine points in the law, what this definition of this word means, you want to have a firm definition. And I think that's what's happening. They're debating back there. And that's good. That means that they're doing their job. They're fleshing out the facts. And this is the stuff you want to see from a jury, that they're actually thinking about it, at least from a defense standpoint, because you don't want them to go in there, immediately convict, and then come out real quick. You want them to debate and discuss.
Absolutely. And Michael, I'm kind of smiling because one thing I should mention, have you ever in your experience seen that jury instructions may not be as clear and as good as they should be?
Absolutely. Which is why I'm saying one would think there would be circumstances where there may be or need some explanation. But you know, we all as attorneys, when we're in these cases, we go through a lot of work for us to make these instructions understandable. One of the things defense attorneys do is they want it to sort of sound the way they want it to sound, and they work the language within the law, and the state does their part in trying to get it to, you know, say something that they want it to say, or just kind of lean in their direction. But sometimes, and I'm sure you've seen this in your career, it can be confusing even for attorneys.
Absolutely. You know, just picking jury instructions at the forefront of a trial, you know, you're debating which jury instruction do we give them? This one's more favorable to the defendant, this one's more favorable, given the facts, right? And it is confusing because just a little change in definition could, in fact, change the outcome of a case. So you really want to be specific and definitive in what you're instructing the jury.
Let me ask you this. Does this, as a defense attorney, what do you think about the malice murder, the top charge? They didn't ask a question about that. They came back with these 4 lessers. Does that tell you anything as to maybe what they've done about that top charge?
I mean, it means that they understand what they're looking at, right? If they had any kind of, if there was any kind of ambiguity to the charge, they would have already submitted the question, because they question about everything else. So potentially they already have her locked in for that. And given the facts that were presented during this case, they were pretty egregious. So I think it's likely that the jury is going to convict on that, but they wanted to be definitive about these last lesser crimes, and I think that's a righteous move by the jury.
All right, so your position is that, see, my thought was maybe there had been enough sort of acrimonial problems in there regarding that malice murder. The fact that how did they, or did the state prove that she had this intent to kill a child? It wasn't some lashing out at the child and hit the child and he ended up dying. Did she intend to kill him? I think that is a sort of higher mountain to climb for the state, whereas the felony murder, I think that's the one that they can sort of all agree upon. So, but you disagree. You think that they're just dotting their I's and crossing their T's.
What I think is that they've made the decision on that first one, whether it's a yay or a nay, the decision has been made. I think they just want clarity, like you said, dotting their I's and crossing their T's on the lesser charges. And that's why they ask questions, right? But I think that they're locked in on that first one already. Or David might have a question about that as well.
All right, let's listen to a little bit of the state closing argument and what they said she did, their position about what she did to this baby.
That girl killed that little boy. She killed that little boy. She cracked his skull out of anger, out of malice. We'll talk about all that later. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred.
Cracked his skull, malice murder. That's what the state wants. But talk to us about what each of these means, Michael.
Yeah, from listening to the judge, the question they had was which of the charges, the aggravated batteries or the cruelty to a child, refers to the felony murders. The way the judge laid it out, he said one of the felony murders, there's two of them, is for the aggravated battery. That's for the hitting to the head and the laceration to the liver. And the second one refers to the cruelty to a child.
Right.
Again, and that's just the general sort of circumstances of the case. So that's the way he laid it out. And that seems like the question they had. So hopefully going back to the jury instructions will clarify that.
And to our point, maybe they're not well written. It may not answer the question for them, but we have seen juries, if it doesn't really help, they may ask it in another way.
Ask away,
so we'll see what the jury does. Stay with us. Coming up next, we're going to switch gears rather and go to Massachusetts for testimony in the Brian Walsh murder trial. We will be picking up with testimony from the cross-examination of the digital forensic examiner who revealed that Brian conducted internet searches that included looking up best ways to dispose of a body. That's next.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We'll bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8/7 Central, only on Court TV.
for you.
Welcome back to Court TV Live. Ashley Wilcott here with Michael Ayala. We have a lot going on today. Yes, it is. And right now we want to turn back to Dedham, Massachusetts, where the trial against Brian Walsh remains underway.
Remember, Walsh faces a single count of murder in the death of his missing wife, Anna, whose body has never been found.
Now, he already pled guilty to misleading the police and to conveyance of a human body. He doesn't deny concealing Anna's death, but he does deny that he murdered her.
All right, we're picking up testimony now with the cross-examination of the digital forensic examiner who revealed that Brian conducted Google searches, and you know what those Google searches were like. All right, let's go back into court.
You referred to as location data, correct?
Yes.
And the location data that was retrieved by apps, various apps that are contained on the devices?
Yes.
And is it fair to say that with regards to apps being able to collect location data, that that service can be turned off in those devices?
If the user decides to.
Okay. And if the user decides to turn off the location tracking aspect of any app, then those app, or that particular app, just does not collect the location data, correct?
To the best of my knowledge.
Okay. So, to the best of your knowledge, then, if someone knew how to turn off the location data for all the apps on any device that they were using to go from point A to point B, you wouldn't have that data that you told us about yesterday.
The phone collects quite a bit of data at all times.
I thought you just answered the second to last question. To the best of my knowledge, if you turned off the apps, the device would not collect location data.
Well, app-specific location data. Yes.
I'm sorry, you're going to have to speak up if you don't mind.
You're asking about app-specific location data, correct?
All right, yes.
Okay, yes.
So, are you telling this jury that if someone turned off the location tracking aspect of an app, that you would still get location data from other sources?
There's a possibility, yes.
Possibility, all right. I want to focus your attention now to Exhibit 161. That is That's the Safari search history?
Okay, yes.
When you say okay, you mean yes?
Yes.
Is that what you mean? Okay. I don't want to confuse you. If I ask a question, just tell me, ask it again, and I'll...
Yes, sir.
That's the Safari search history of the Apple iPhone 13 mini, and it ran a date range of December 25th, 2022 to January 4th of 2023. Is that right?
Correct.
And then that same exhibit, and I think it was referred to yesterday, contains what was referred to as Chapter 2. Do you recall that? And the Chapter 2 is the Safari web history of the same device that runs from December 31st, 2022, from 9:28 a.m. to 9:31 a.m.
Correct.
Is that correct?
Yes.
And you testified yesterday that even though the data would be collected and extracted from those two sources, the search history and the web history, that the web history would generally contain additional and more detailed information?
That's correct.
And who was it that decided then to limit the web history information included in Exhibit 161 to only 1 day for just a couple of minutes?
It was a decision by the prosecution team.
Okay. And so you told us yesterday that you work for the Norfolk County District Attorney's Office, correct?
Yes.
So, and you told us yesterday that you're an investigator, correct?
Yes.
And So as part of your role as an investigator with the Norfolk County District Attorney's Office, is it fair to say that you take direction from the district attorney that's prosecuting a particular case?
More collaboration. We bring the investigative piece, and they bring the legal advice and piece to the case.
Do you ever then inform the district attorney, whoever it is that you're working with on a particular case, that, for instance, web history would have additional information that might help explain entries that were found in the search history?
I present the data that is extracted from the device.
So my question was, do you ever take the time to explain to the district attorney assigned to the case you're working on with them that the web history would contain additional information in addition to the search history?
Yes.
So in any event, with regards to Exhibit 161, you were instructed or advised to only include the web history for one day, December 31st, and only for a few minutes.
Well, that particular searches were on Apple Maps, which were contained on Safari history, search history.
Were you told, were you instructed not to include certain information in Exhibit 161 then?
We had the date range of December 25th, 2022 through January 4th, 2023, sorry.
And what about the web history? Were you instructed only to limit the inclusion in Exhibit 161 to that one day, December 31st?
We only chose to do that specific, those specific searches from 9:28 to 9:31 a.m.
Okay, I'm just going to ask, and it's probably me. I can barely hear you.
Sorry.
I'm sorry. I might be going deaf.
That's fine.
Durs, are you able to hear?
And
Great.
Apologize.
That's my concern. But you need to be able to hear him as well. I'm concerned about that.
I understand.
Attorney Timpson.
I understand.
Do my best.
Yesterday, you were asked, let me ask this. You would agree, wouldn't you, that in the search history included in Exhibit 161, that at page number 1, number 9, there are indications of a search involving Expedia and other flight-related searches?
Could you show me that, sir?
Sure. Do we have Exhibit 161? I see. May I approach you?
You may.
Thank you, sir.
Should I refer to you as Trooper? Or if you have another title, I just don't want to misstate.
No, that's fine, sir.
Trooper?
Yeah, that's...
So, Trooper Keith, I want to focus your attention now to page 1 and the entry number 9. Am I correct in saying that that references a search related to Expedia?
That's correct.
And that search occurred at 12:25:22 at 11:39 a.m. Is that fair to say?
Yes.
And those searches related to Expedia, they continue through record number 20 at page 2. Is that correct?
Yes, it goes from Expedia to Check a Flight to Check a Flight JetBlue.
All right, we're going to take a break here, folks, and when we come back, we're going to hear more about those internet searches and whether this defense can kind of shape them in a way that, I guess, doesn't hurt them as much.
We're going to see.
Keep it here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala here with Judge Ashley Wilcott, and it is day 5 of testimony in the murder trial for Brian Walsh in Massachusetts. Walsh is accused of murdering his wife Anna on New Year's Day 2023 and then hiding her body.
While Walsh has pled guilty to charges related to disposing of her body and misleading investigators, he says he didn't kill her and that she died unexpectedly. Let's head back inside the courtroom now. A digital forensic analyst with the Massachusetts State Police is on the stand for a second day. He is on cross-examination by the defense about searches conducted by the defendant.
So yesterday you told us and you testified to one entry having to do referring to JetBlue, correct?
Yes.
There's a number of searches in Exhibit 161, isn't there, that have to do with searches for Expedia and flight information?
Yes.
And once again, if you were to look at the Safari web history of the same device for this same information at the same time, you would find more information and put context into that search. Is that accurate?
Yes, there would be more information.
Okay. But as you sit here today, and based on what is and is not included in Exhibit 161, you can't give us more context to any of those searches regarding flight information, can you?
No.
Yesterday, and I'm going to ask you to turn to page 4. Yesterday, you were asked questions about an entry on page 4, record number 42. Am I saying that right when I refer to record number 42? Do you understand what I'm talking about?
Yes, sir.
Thank you. That was a search regarding what?
Number 42. Would you like to read the date, time, or just the search term, sir?
You can read it anything you want,
Okay.
yes, to make it complete.
Item 42. The search occurred on December 25th, 2022, 12:28 p.m. And the search was Xmas Day plane crash.
Okay. And those types of searches, and when I say those types, the subject matter that's contained in record number 42, it continues through record number 45 on page 4, doesn't it?
Yes.
And that is timestamp 12/31/03 at record number 49.
Correct.
Now, yesterday you were also asked about a specific reference, and once again, page 4, record number 53.
Mr. Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please. All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the 1st degree. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure, and I know that you probably had a lot of places you would have rather been this week than here. I do want to thank you tremendously for your service. You have shown up, you've been on time, and you've paid thorough attention. You've taken in a lot of information this week, and you obviously, from the fact that you've deliberated over this, you've looked at this very closely. So with that, your county appreciates the work you've done, and you will receive a stipend. It's just a token of the county's appreciation. You are free to leave for the term. You're also free to, you can certainly step back into the courtroom through the other door if you wish to, or hang around if you want to speak with the lawyers, but you don't have to. You don't have to talk to anybody. You're welcome to leave at this time if you prefer. If you do, turn in your badges on your way out, and make sure that your notes are in the jury room. And I really appreciate it. Y'all are free to go. Oh, was there anything hold the jury for just a second. Ask them to step into the jury room. No, ask them to step into the jury room. Ask them to just step into the jury room. Yeah. Chet, if you'll pass this down, please pass this down to the lawyers. I do want to let you all review the verdict form, and let me know if there's anything else that either of you are asking me to consider. All right, may the jury be released. Mr. Lamb? Yes, Your Honor. Mr. Gamble?
Yes, Your Honor.
All right. All right, my proposal would be to let's proceed with sentencing. I would like to give you all about 15 minutes and come back in, and I'll hear from both sides, and then I'll pass sentence. So it's 4:35. I'll be back in at 10 minutes until 5, and go ahead and hear from both parties and conduct sentencing. Thank y'all. All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the, I know that the aggravated battery charges merge with the felony murder charges. And I believe the cruelty to child does as well, but I want to see what both parties indicate.
No, sir, I don't think we agree.
Okay. What is your position on that?
The state's position is that, of course, the court could impose sentence on, that you go straight down the line. The court could impose sentence on count 2, which is felony murder. Count 3 felony murder would be vacated because you can't be sentenced for 2 murders in the same case when there's only 1 victim. Count 4 aggravated battery would merge with count 2 felony murder. Count 5 aggravated battery would stand alone because you would only merge 1 felony with the felony murder, not 2. Even though the felony murder, because the felony murder is.
Well, can I see the indictment? Will you hand me up the indictment from the?
I mean, I have a copy of it. I don't know. I guess
it's with the exhibits.
Is it in that?
Well, if you have a copy, that'll be just as fine.
I just counted all the exhibits. I didn't even think about that.
I don't know. I do have,
you can hand it up. That's
yes,
fine, Laura.
I do have a copy.
All right.
So
let the court reporter sit back down.
Yes, sir. Yeah, please.
All right, let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively, and I mean.
Let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect
Can we
to,
take a break? Are you looking for the indictment?
Yes, sir.
Okay. If it's not in there, then they need to hold everything in that. Okay. All right. All right. Okay, you can go ahead.
so even though which count is the count 2 is the one that relates to the aggravated batteries?
Yes.
Is that right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or whatever to the brain and to the liver. That
Head and torso.
Or
yes.
Head and torso, right? That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. A finding of guilty on felony murder. If there was a finding of aggravated battery only on the torso, that would be sufficient to support it. So since either of them will support the felony murder, only one of them merges. And then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get count 3 is vacated, count 4, merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge; it's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. I mean, if the court wishes to take it.
Maybe we should take a recess.
Well,
I
I'm
thought,
looking right now, Judge.
Okay. And I did say, I mean, you do agree that then that the felony murder, the 2 felony murders, 1 vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
Okay. But the fact that count 6 would have merged with count 3 doesn't affect count 3?
No, sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that, the question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or.
Right.
But it includes count 4 or 5, or 4 and 5. I mean, they could have found him guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take. I'll give you some. I'll alert you when I'm ready to address that. All right, I'm being told that the state and the defense agree that the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, that I think that 4 and 5 would merge with count 2, and that being the case, the state's position is that the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes,
yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, there's very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The vacation, the fact that count 3 will have to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 5 to 20. 5 to 20. Okay. All right. All right. I'll hear from the state first.
Your Honor, the state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2, with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim, and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking. But I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill. And that would be the distinction between count 1 and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. At life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not. The father of the child is not. Father and aunt are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
Your Honor, We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as a sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that she will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now obviously she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask that on the cruelty to children, that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case and I've, considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder. Even the charge that, would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on, so on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence. And life while you're in prison. I guess you just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
Forward it to Mr. Gamble for review, and then to Your Honor.
Thank you.